The Justices of the Appeals Court, now sitting at Boston with Ben and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Henry. To my left is Judge Desmond. And together we are your panel for the 6 cases this morning. I see we have a lot of veterans here, so you know the rules. 15 minutes per side, no opportunity for rebuttal. I want to emphasize that 15 minutes is generally not a good deal of time, so we urge you to cut to the chase to the extent possible. We have read the briefs. We're familiar with both the facts and the arguments, so please, as I say, cut to the chase. If you find that you have time left on the clock, there is no shame in sitting down. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the morning, DOULL versus BRAMANTI and LYONS Court Reporting, Inc. That is 2023 P595.
May I proceed, Your Honor?
Yes.
Good morning, Honorable Justices. My name is Attorney Chris Sobchak. I'm here representing the plaintiff in this case. Before I commence, on behalf of the 12 jurors next door, I do want to thank the panel for allowing for the time change. Now, addressing to the cases, this case, it's a very simple case. Despite its convoluted procedural and factual history, before the court are 3 very simple issues of first impression. 1, when dealing with issues of special motions to dismiss in Superior Court, should they be filed directly with the court because there's a statutory notice of deadlines, or should they be served by Rule 9A and a notice be filed concurrently and Rule 9AE be amended? 2, when you have a special motion to dismiss and it's been served or filed, do the courts should follow the statute and follow the statute's purpose and expeditiously resolve it? And if the defendants then subsequently choose to withdraw or do anything else for that reason, that withdrawal will be treated as a judgment on the merits, and then the punitive purposes of the motion, which is designed to persuade parties from not pursuing frivolous case, be implied and attorney fees be issued. And 3, when you have a judgment in a 938 case that's silent on issues of fees, costs, or attorney fees, it should be treated as a judgment on the merits, because that's what judgments are. They're not an agreement, they're not a stipulation, it's a judgment. And if there's a judgment in a 938 case, attorney fees should issue. All 3 of these issues have not been addressed in this court. Straight on.
Why, in terms of the withdrawal of the counterclaim?
Yes, Your Honor.
This case, isn't it just like the Connolly case, with the exception that they did not have the ability to withdraw the counterclaim as of right because you had filed an answer. Now, because of that, the judge could have conditioned the withdrawal on the payment of fees, but did not do so. Once the judge did not do so, weren't you left at best with a potential appeal that the judge abused his discretion in not conditioning the withdrawal of the counterclaim?
Yes and no, Your Honor. The case is different between Connolly because not only was the withdrawal not available, here, once the special motion to dismiss was filed, the court did not deal with it expeditiously. Instead, the court allowed the defendants to file motion after motion after motion after motion. In fact, as the record shows, after the motion to dismiss was filed, defendants first filed an emergency motion to strike it. The court denied it. Then the court ruled that 9A applies and you have to refile by 9A.
Hold on. The court ruled that 9A applied. 9A applied from the outset, right? I mean, you chose the forum. You chose the forum.
Not always, Your Honor. 9A applies in most motions in Superior Court.
You chose the forum to file your motion, and 9A applies. And so the fact that you didn't know that 9A applies and you kind of gave your opposing side a preview because you didn't know the rules, how can we fault them for that.
Well, with all respect, Your Honor, I do know the rules, and actually 9A doesn't apply. That's why it's an issue of first impression. 9A doesn't apply in every single instance. There are times where it has to be filed directly. When there are time-sensitive motions, Rule 9E identifies those, and you file a notice. In this case, it's silent. This trial judge ruled that 9A applies, and therefore we follow this. But prior to this trial judge ruling, there is no rule, there is no statute, and there is no appellate case that specifically says when you're dealing with a special motion to dismiss, you are to serve it first by 9A and then subsequently file it and file a concurrent.
But even,
Well, did you include that in your notice of appeal?
I did. The notice of appeal includes all the issues dealing with this, with the 9A portion, and those issues with the court failing to expeditiously address the special motion to dismiss, which then court then allowed the defendants more time to oppose it, then allowed them time that they don't have to oppose it. Then the fourth time, the court finally allowed the defendants to file a separate issue, which is the issue of the withdrawal.
Well, but back to the Connolly issue, how do you address the statutory language that talks about when the judge, if the judge grants the motion, they can award attorney's fees?
I agree that in this case, the court did not get to the motion on the special motion to dismiss because the court refused to follow the statute and address it expeditiously. The court did not just say, here's the motion and we're going to allow you withdrawal. The court addressed 4 different motions before that, one of which rendered the final one, rendered the motion to dismiss moot. And then therefore the court did not award the fees.
Right,
The
so
court should have.
what's the hook that lets you get fees then? Because it's not that the judge granted the motion.
The hook to get the fees is this court's ruling that the trial judge did not follow the statute. The trial judge did not expeditiously address the motion to dismiss. The trial judge went over well beyond her discretion, allowing the defendants to do 3 separate motions and to render it moot. The court should reverse all those 3 prior rulings and send it back for the court to address the motion to dismiss expeditiously as the first thing before the court.
well, you're skipping over the step where the offer of settlement was accepted. And given that at that point in time, at most, you had the potential for an appeal of the issues you're seeking to raise now, why doesn't the silence in the offer cut the other way? That if all you had at that point was a potential appeal you could have pursued, and you accepted the offer that was silent on there, why doesn't that hurt you?
It doesn't hurt me, and then there are 2 separate time issues. The issues with the special motion to dismiss happened in December and January. Down the line, the only offer of settlement my clients accepted was the one against BRAMANTI and LYONS. They've settled, BRAMANTI paid, and they're out. Mr. Hoey did not made an offer of settlement. Mr. Hoey made an offer of judgment, and a judgment was to enter against him. The offer of judgment was silent on attorney fees and costs. The offer of judgment is silent to any waiver of appellate issues. There's a substantial difference between accepting an offer of settlement with BRAMANTI and accepting an offer of judgment against Hoey. The judgment is what actually allowed me to proceed forward and have all the appellate issues go forward. Had Mr. Hoey accepted the plaintiff's demand to settle, and they have settled with them, very likely the stipulation of dismissal would have waived all appellate issues and the case would be long over. But Mr. Hoey didn't want to do that. He wanted to play games even with his offer of settlement, of judgment, and he wanted to modify it, so that's what he did. My client accepted an offer of judgment, and when a judgment enters, it should have, just like any other judgment in this courts, a effect of here is a judgment for the plaintiff against the defendants. It was silent on the attorney fees, and therefore, under 93A, the very few instances in our Commonwealth where there are punitive measures to discourage this bad conduct, it should apply. Massachusetts has very little punitive damages. Wrongful death, the special motion to dismiss, and 93A are pretty much just almost most of it. And if the trial courts start gutting those provisions, there are going to be 0 deterrents in our courts.
So this may not surprise you, but we're not interested in being involved in your games or even figuring out who's doing the games. It seems like both of you should be smart enough to figure this out, reach resolution, and disengage. So I don't really want to hear about who's behaving badly because I don't know, in my house, when both sides are behaving badly, we just take the toy away. We're done. We don't do this. So here, is there a finding of liability under Chapter 93A?
In my opinion, yes. A judgment.
Okay, but I'm not interested in your opinion. I want to be interested in the law and the facts, okay?
There is no law.
And his offer of settlement was that there was no liability under 93A, and you accepted that, right?
I didn't accept his settlement. I accepted his
You
judgment.
accepted a judgment that, where he said there's no finding of liability.
And if the court was to take a ruling that a judgment based on a offer that denies liability is not actual judgment, then every time you have a criminal defendant say, I am innocent, but I'm going to plead guilty, then that's not a judgment.
We
Every
don't
time you have
allow
a
that to
housing
happen,
court.
but here, you accepted his offer of judgment that said he's not liable, right?
I accepted his offer of judgment for the plaintiff against the defendant.
It
That's
had,
why,
it had some language in the offer. Did you, right?
yes, I read the language, and the
Okay,
language
so
doesn't
what-
affect,
What did the language say? Tell me.
that they're denying liability, and that's it.
And you accepted that.
And I accepted his offer of judgment because judgments
With
are
that
different.
language. I mean, let's not play games.
Correct, Your Honor. That's
Okay,
why.
well, that's what it seems like we're doing, with all
Well,
due
that's
respect.
why it's an issue of first expression. There's a
I know you
difference between
think it is.
settlement.
I'm not convinced it is. I
Then
know you think it is. I'm not convinced. So I'm trying to get you to persuade me that it is. But I
There-
need you to answer some questions directly.
okay.
Okay? So
Ready
first
to answer.
off, in the offer of judgment, what was the language? Tell me, what was the relevant language in the offer?
Judgment for the plaintiff. That was the relevant language.
That was all
mattered
that
to
was
me.
contained in it?
That was all that was relevant as far as the plaintiff was concerned. There was a number, there was what was absent, and then it's going to be a judgment for the plaintiff against the defendant. The fact that the court saw it differently is evident by the fact that when plaintiffs filed an offer, acceptance of the offer of judgment, the court actually dismissed the case and entered judgment for the defendant. So clearly, even the trial court was confused by what the offer of judgment said. But the
Were
issue
you
before-
confused by it?
No, I saw it simple as an offer for judgment for the plaintiff against the defendant on a 93A case.
Was that the only language in the document?
That's the only language that was
That's the only
legal.
language in the document, yes
It's
or
the
no?
only language that was legally relevant to my client's acceptance.
That doesn't answer my question. Was that the only language in the document, yes or
No,
no?
it's not, and that's why if the court is to rule that all the extraneous language somehow is incorporated into agreement of judgment, then that's what this court rules. This is why it's three issues of first impression. There is no law that directly says so. I interpret it such way in the absence of guiding law. Defendants clearly accepted it differently in the absence of guiding law. You three justices decide what the guiding law is, and we move forward. But at the time it was accepted, there was no guiding law. And that's why my client took what it is, a judgment for the plaintiff against the defendant, and based on the established law in other cases, if it is silent on fees, and it's silent on interest, and it's silent on attorney fees, and the statute calls for it, those are included.
So
It was silent on those three issues.
what is your authority that attorney's fees are included in cost under that statute?
Chapter 93A, the statute says, if the court finds, then there's fees. In this case, my argument is the judgment is the finding. That's the issue of first impression. I agree.
That
there was
sounds
no,
like you're playing a game.
I am reading the language as it is. That's all we can do. As lawyers, I don't get to interpret the law. I only get
No,
to follow
what it
what's
sounds
written.
like is you thought, oh, wow, he's being silly and I'm going to take advantage and then I'm going to make this move for fees and I'm going to really get him, right?
I do what's before me.
The fees are 3 times the judgment, right?
Which, with all the respect to you, Justices, that's the purpose of 93A. Oftentimes, when you have cases that are 93A or class action cases, you may get a 17-cent coupon and the lawyers make 600 millions. The reason why the statute is there in those instances to allow those attorney fees is because the greater good is protecting the citizens of the Commonwealth to stop this type of behavior.
So-
Like I said,
Go ahead. So,
No,
so the judgment that you accepted was for like $12,000, somewhere abouts, right?
$12,000 plus interest, costs,
The
and
figure,
fees.
the figure in dispute for transcript fees was $1,200?
The issue in dispute was primarily the declaratory judgment, secondary, the 93A issue. The amount of the fee was minuscule to the issue, which is why, again, this is a 93A
The
case.
dispute was over who was going to pay for the transcripts.
No, the dispute that my clients had was to make sure that they are not responsible and they're not being pursued for that time on for something that they clearly never had the duty to pay. By the time Attorney Hoey used his firm to pursue this frivolous motion against my client at trial court, the case was already over. They've lost the verdict. So under his own fee agreement, my clients could never be responsible for those fees. So he only used his lawyers under the guise of pretending to represent BRAMANTI to pursue my clients to cause more emotional harm. That should be the type of behavior that our courts disencourage, which is why I served the 9-3A letter. I gave them a chance to withdraw your frivolous motions. They did not. I opposed the motion, laid out all the facts, and on the last day, they finally withdrew the motion. They answered the 9-3A letters. Nowhere in those letters did it say, oh, by the way, we already paid the fee, therefore the motion issue is moot. They stayed silent. They just denied everything. So then I, to protect my client from, yes, a relatively minuscule harm, but because he didn't get his justice in court on the first issue, I wanted to make sure that at least he didn't get stabbed in the back second time from having his former lawyer sue him for $1,000. So I filed the suit. I pursued to get a declaratory judgment to prove that he doesn't own that money.
Right, but it seems like that he might have started an ill-advised game, but then at some point he realized that was a mistake and offered you almost 10 times that amount that was in dispute for settlement purposes. Is that wrong?
It is wrong because by the time he offered that amount, that wasn't the issue. Had this been a breach of contract case? Yes. That would have been a reasonable, generous settlement offer, but it's not. It's a 9-3A case, and by that time, my client was already forced with multiple motions to dismiss that they lost, motion to disqualify that they lost. By that time,
That they lost without prejudice.
Correct, but they incurred costs.
But there was still an open issue going forward, if this would go to trial, whether you could even represent your client at trial.
Potentially, and the courts could, and this is why in this...
And yet, they settled it, so...
They didn't settle it. They made an offer of judgment. BRAMANTI settled it, and that's why they're not here, Your Honor. There is a huge difference. Settlement and judgments are different. But I have 5 seconds now, I'm
I
over.
understand the distinction you're drawing, but the point is that they did something to make this case be resolved.
No, they did something to make it resolved by what they understood, not what my client understood.
Thank you very much. We will hear from Mr. Curtis.
Thank you, Your Honors. And may it please the Court, Robert Curtis for the Appellee Law Offices of David J. Hoey. I think all three of you have a good understanding of what this case is really all about, just based on the questions. Working backwards, though, Rule 68 expressly states that when there's an offer of judgment, judgment shall enter to the effect specified in the offer. So this isn't a question of first impression. Maybe in the courts it's a question of first impression, but Rule 68 is competent authority to follow as well, and it's pretty clear, to the effect specified in the offer. The offer said $12,000 payable to a charity, not to the estate, and no admission of liability or that the estate had been damaged. When that was accepted without condition, that became the judgment. All of that language became the judgment, not just the $12,000 piece that my brother wants to focus on.
Right, but it's a little, I mean, I hear what you're saying. It's a little odd, though, because it's judgment for he'd be the plaintiff, right?
No, we were the defendant in that case, too.
It was judgment for his client that denied, but that said there's no liability.
It was, maybe I misunderstood your question. So my brother represented the plaintiff.
It's a judgment that says he wins, except he doesn't.
Right, exactly. And the reason for that is, and I mean, you know, I don't want to go beyond the record here, but I mean, the reasoning behind it is my client didn't want to litigate this. As you said, my client looked at it and said, I don't want to get involved in this. He looked at what he'd have to pay in attorney's fees all the way up the chain, and unfortunately we're here today and he's paying for this as well, but he looked at it and he said...
You're both punishing each other just fine.
Well...
Well, you bring cases after case.
Well, I mean, all of the cases have been brought by the other side, and we've been defending them.
Except this one.
No, we were the defendant in this case.
Okay.
So all of them, we were the defendant.
Why an offer of judgment and not an offer to settle?
I think there was conversation, and again, this is probably beyond the record, but I think there was conversation about a settlement that wasn't agreed to. So my client said, look, Rule 68 is a tool available to me, and there's authority out there, I think it was mostly federal cases, but similar language in Rule 68 that basically said, an offer of judgment is an offer of settlement. It's the same thing. The purpose is to resolve the litigation without having to go to trial. So when he couldn't secure a settlement on terms he was, happy with, he said, all right, I'm going to make this offer of judgment, and under the rule, if a case goes to trial and a jury awards greater than the offer of judgment, or I don't even remember the full mechanics of it, but it protected my client, basically. So that's why he did it this way. If he couldn't secure a full-on settlement out of court, he went with the offer of judgment here. And that was the point. And granted, the amount he agreed to pay was a lot more than what was actually in dispute here, but he looked at what he'd end up having to pay in attorney's fees if this thing went all the way full to a trial, and he said, I'll pay this money now. I'm not going to pay it to the plaintiff because I don't believe I owe this money to the plaintiff, but I'll pay it to a charity. We can all go home and it's the end of the day. And that's what he intended here. And unfortunately, we are still litigating this, but that was the intent behind this.
But then go ahead. But then he chose a charity and you disputed that.
Well, we did. If you look at the information that's in the record, the charity that, I mean, he mistakenly assumed it would be the same charity that was listed in
Your client.
Yeah, my client mistakenly assumed it would be the charity that was listed in Ms. Doull's obituary when she passed away. And that's shame on him for thinking that. The only reason he objected, well, first of all, there was already a Rule 59 motion filed. So the case wasn't over yet. The other side had already filed a Rule 59 motion trying to modify the judgment. So at that point, we said, well, look, the charity that was named is a charity that was founded by Attorney Sobczak. It's his charity, the plaintiff's attorney's charity. And we did a little bit of digging into it. There wasn't a whole lot of activity going on. A lot of the documents that need to be filed tax-wise hadn't been filed up to date. The website for the charity hadn't been updated in a number of years. And we said, wait a minute, this smells funny. I mean, you know, we're going to be paying this money to counsel. And how do we know where it's going to go? So yes, he raised that issue at that point because the case wasn't over. If there was no Rule 59 motion, it probably never would have come up. But because there was another motion pending, we said, okay, we're gonna bring this to the judge's attention too and see what the judge does with it. The judge didn't want to hear it, and we didn't appeal that order.
The judge, no, it's not that he didn't want to hear it. He heard it and said, pay the charity of his choice.
No, well, right. I mean, hear the excuse, basically. She said, pay the charity. That's, you know, you agreed to a charity of the plaintiff's choice. This is what they chose. We're not going to get into whether or not it's an appropriate charity. That's what I mean. I didn't mean no actual hearing. I meant didn't want to get into it. But so, and once that order came in, if we wanted to keep fighting on this stuff, we could have filed a notice of appeal on that. We didn't. And we didn't because we said, okay, shame on us for making an assumption of what charity would be named, and we walked away from that issue.
Right, all right. So he has some potential ethical issues if he does not use that money appropriately for charitable purposes. So leaving that aside and making sure he understands he's got some ethical obligations on that, I mean, basically, he files his motion to dismiss under the anti-SLAPP statute, and then you asked to withdraw those claims. So why is that not basically an order granting his motion?
Because of Connolly. And when you look at Connolly,
And the difference with Connolly is that there was no answer in Connolly.
you're right.
And couldn't the judge here have conditioned payment of attorney's fees in order to grant the motion to dismiss the counterclaim?
She could have. She didn't.
No, I understand
Right,
that.
no, but that's an important distinction because it's a discretionary matter at that point. You know, it's when under Rule 41A2, where you don't have the right to withdraw your claims, it's discretionary. And the judge, she says on the record, I've read all the papers, I understand what's going on, I'm allowing, without prejudice, the voluntary dismissal of these claims. That's a discretionary decision, which she did with a full understanding that we're fighting over $1,100 that was paid 3 years ago. So that was a discretionary decision, and that discretionary decision is not addressed anywhere in the brief, so it's waived. So at this point, once that issue is a dead issue, we are squarely on point with Connolly, 100%. You've got, in Connolly, the other side, I believe they actually served their motion under 9A. The opposing party looked at it and said, you know what, this isn't, for whatever reason, this isn't worth fighting. We're going to withdraw our claims They did it after being on notice that there was a pending anti-SLAPP motion. The judge allowed it, and the court, issued the Conley court issued its decision saying that yes, under those circumstances, the issue becomes moot. And once it becomes moot, you can, and the claims are dismissed. The court did not grant the relief under the anti-SLAPP motion, so therefore there's no fees. And this is squarely on point with that. You're absolutely right, and we acknowledge this in our brief, that the only difference is the fact that it was not a withdrawal of the claims as of right, it was by motion. But once that motion was allowed and not appealed, it's exactly the same as Conley.
He says he appealed that, though. Why is he wrong? Are you just saying it doesn't matter?
I'm saying you look at
because he
his
didn't brief it.
Yeah, right, exactly. And that's the rule. If it doesn't matter if you preserve an issue, by objection at the trial court or expressly put it in your notice of appeal. If you don't argue it in your brief, it's waived. And that's exactly what happened in the Subcheck 1 case that I cite in my brief, that the exact same thing happened. There was a dismissal under Rule 41, but he didn't argue that issue in his brief. He argued a bunch of other things, and the panel actually sanctioned him for having a frivolous brief at that point because he didn't address the actual dismissal that gave rise to all of these other points. And that's exactly what happened here.
So if we were to grant your request for attorney's fees, why are we not just throwing fuel back on the fire of this dispute? Because I think we're not interested in continuing babysitting this.
I hear you, but again, go to the public record. This is the fourth appeal now between Attorney Subject and my client. Every time the appeal was filed by Attorney Subject, every time my client was defending in the appellee seat, every time. So we're hoping by granting our request for fees, that's water, not fuel on the fire. We're hoping. I mean, nobody knows, but we're hoping that's the case, especially if there's some strong language maybe with the sanctions that, suggests to Attorney Subject, this fight is over. This fight that started in 2017 when you separated from the Hoey Law Firm is over. It's 2024. We're done. You need to say that. Because if you don't say it, we're going to be back on some other frivolous suit somewhere down the line somehow. Because Attorney Subject is smart enough to figure out a way to initiate some sort of claim. And he will. He'll do it, and we'll be back here. And my brief next time will have 10 pages on the request for attorney's fees because I'm going to have to come hard a little stronger next time, unfortunately. My client just wants to be done with this. I think I'm done unless there are any other questions.
Hearing none, thank you very much.
Okay, thank you very much.
The case is submitted. Our next case of the morning is Commonwealth versus Berry, 2023 P620. Go ahead.
Thank you. I'm just waiting for the timer to change.
You actually want 15 minutes. Okay.
I do. Thank you. Good morning. May it please the court, Barry Oskern on behalf of Mr. Berry. This is an unusual case. I can say as a former prosecutor, as a trial attorney, I've never seen this scenario come up before. The prosecutor thought he had a slam dunk on 6 of the 7 charges, but for the kidnapping, asked for an instruction on joint venture for the kidnapping alone. That was granted, and then both parties made their arguments. And I think everybody would agree as a trial attorney, you cannot argue unless you know what the judge's instructions are going to be.
Okay, but the Commonwealth, in its brief, says that you claim prejudice because the argument would have been different had you known they were going aiding and abetting on everything. And you argue that in your brief, but you never say how the argument would have been different. This is your opportunity to...
And I think in my brief I suggest you have to remember when the jury came back with the question, there were actually two questions. And the first one was, can a flashlight serve as a dangerous weapon? And I think what that indicated is that at least one person on the jury, if not more, was not convinced that there were two firearms. And remember, the Commonwealth's theory of the case is that both men came into the house, barging in with firearms, committed crimes. At the end of the day, only one firearm was found. And secondly, there was evidence, I think the most serious charge was the assault by dangerous weapon, a firearm. When Mr. Berry is seen coming down the stairs, the officer says he pointed a gun at me.
Not guilty verdict?
I'm sorry?
Was that the not guilty verdict?
That was a not guilty verdict. And I just want to say, not only did the officer testify to that, but the other man who was on the floor in the living room next to the stairway, he said he saw Mr. Berry point a gun. At the end of the day, the jury came back with a not guilty on that, which also suggests that they didn't believe that he had a gun in his hand. And I think that was a foundation for the question.
I just need to back you up. I read both briefs, and I could not figure out the layout of this apartment. So if someone could just, because I couldn't figure out, are the stairs internal? Are they external? What floor were they going to? Were they the front, the back? Totally did not understand the layout of this place.
My understanding is that when you walk into the house, the living room where Mr. Polanco was on the floor is immediately to the right. Straight ahead are stairs leading to the upstairs. And it sounds like Mr. Berry, when he entered the house, went upstairs, started rummaging around, looking for money, looking for drugs, comes back down the stairs. And my sense of it is that as he comes down, the living room is essentially adjacent to where the stairs empty out into the entryway. Mr. Polanco is on the floor, not that far away. I believe that there was a cell phone which was recovered near the scene of the stairs. My take on it was that Mr. Berry had the cell phone in his hand. That was mistaken for a firearm. But somehow, somebody on that jury, if not more people, was not convinced that he had a gun in his hand.
So where was the gun found? Because that was the other thing I couldn't figure out from either brief.
My sense of the layout of the land was that the gun was found on the floor, somewhere between the stairs and where Mr. Polanco had been laying on the floor in the living room.
So,
And I think there's an inference that it was Mr. Berry's co-defendant who had the gun, because Mr. Polanco...
Clearly visible when they entered the apartment, right?
Pardon me?
It was clearly visible when they entered the apartment.
Somebody saw a gun when they entered the house. Right? And Mr. Polanco says, I think, twice. First, I think he says, I was struck by something. I think it was a gun. The next time he says, I was struck a second time by the gun. During the course of the trial, the prosecutor sort of takes that up and says, when you were struck by the gun. Ultimately, that's the only gun which is found.
but just backing up on 2 points. The first point is there's no issue that your client knew the other fellow had a firearm, right?
Well, I would disagree.
Okay.
I don't know that we know that. We know
Like
that...
most favorable to the Commonwealth, do we know that? Even if you don't agree?
That's why I asked, was it visible when they came in the door? I mean, if
I would
it's
say
visible
it's
to the victims, how come the co-defendant not see it?
It's a fair inference. Do we know it for a certainty? We don't.
No, but we use some fictions here, and one of them is we look at things in the light most favorable to the Commonwealth. So I'm just trying to understand, if we look at it in the light most favorable to the Commonwealth, did your client know that the other guy came in with a gun, that he was armed.
I think that's a reasonable inference, and that would favor the Commonwealth.
But your point, I take it, is that we don't look in the light most favorable to the Commonwealth in this context, because this is not a sufficiency argument. It's whether or not you were prejudiced by the change in the jury instructions.
Correct. And I want to say, I think the initial question, which was, what would that argument have been to save the case? I actually look at this a little bit differently. The first being, first of all, was there an error? And I would argue, under the rules governing arguments, there was an error. I don't know that the Commonwealth concedes that in their brief, but I think it's clear when you get up and argue, thinking...
Let's assume that there was. So
Okay.
what would the argument have been?
So the next question, though, I think would be, okay, an error was made, where's the prejudice? And this is how I look at it, which is, if the judge had not expanded the instructions, if the judge hadn't given the initial instruction, what we know is that at least one charge, if not more, the jury was stuck. They weren't agreed unanimously that there was going to be a conviction.
Well,
That's
but
why they had to ask.
Right, but they might have gotten there. So the question is, how would you're saying this was unfair to the defendant because they thought the jury instructions were going to be one way, and then after the fact that they changed. So what would if the jury instruction, if you'd had proper notice and that it was going to be a joint venture on all charges, how would the argument have been different by your client?
Okay, I think the argument would be to focus on the fact that there was only one gun. So let's look at the charge. One of the charges was possession of a firearm. If there was only one gun, the only way that you could reach Mr. Berry would be under a theory of joint venture. And again, it gets to, was he aware, was he not? I think you could argue that he went upstairs.
Well, again, I'm talking about at the point of entry, the gun was visible, right? They dressed up as police people, right? And had a gun at the point of entry when they entered the home. Do you agree with that? I thought we were past that point. I thought you said that was a reasonable inference from the record.
It is a reasonable inference, but again, I think when I look at, let me get to the question, was there prejudice? I think you're asking me, could an argument have been made to save it? And I'm saying the jury, which seemed like it wasn't headed towards a conviction. They had questions, and I think a reasonable inference had been, if the judge had not expanded their ability to apply the theory of joint venture, what would the jury have done? We don't know, but we know at least at some point the jurors could not agree on a conviction on one or two counts, but the judge gave the new instruction, and all of a sudden the jury said, oh, okay, now under joint venture we do have grounds to convict.
Right. So
that to me is the prejudice.
All right, so I think we understand that, but we're asking, how would counsel's argument have been different, and if it would have been? And I don't know what your answer is to that.
So again,
Your answer may be, I don't have to answer that question, but we'd like you to answer that question, or you could just leave us to wander on our own.
well, I think my best answer is, and again, not being trial counsel, not being as intimately.
Your best answer is?
I think I would have focused on the firearm and the fact that only one was found. But again, that's my best answer. I would really have to defer to trial counsel and say, what would you have done differently? But I don't think that this case...
Have an affidavit from trial counsel?
I do not. I do not. I don't think that the resolution of this issue should rise and fall on what would trial counsel have done differently. I think the real question is, was it fair to trial counsel, after having a colloquy as to what the instructions were going to be?
I get that, but what's the prejudice?
The prejudice is that the judge gave the jury an additional roadmap to find their way to a conviction, and in fact, the jury took those roads, and that I'm going to use the expression, the rules of the game had changed without counsel. I would say that's unfair to the attorney.
I'm just trying to figure out how it is. I mean, no harm, no foul, right? So tell me how it was unfair. Would they have put on a different case? Had they known going in that the whole case was going to be a joint venture case?
I'm saying, well, I think they would have made a different argument. And again, I think the argument would have focused on the issue of firearms because obviously they had a question about it. But I think, again, to ask the question, well, what would counsel have done differently to change things? This was a strong case for the Commonwealth. I think everybody would agree with that. I will say in some of the federal cases that I cite, the answer is, regardless of how strong that case is, regardless of how overwhelming it might seem, and I'm going to cite to United States versus Mendoza, and the appellate court described the evidence against the defendant as being, quote, nearly overwhelming.
Is that the D.C. Circuit case?
That's out of the Fifth Circuit.
Fifth Circuit.
Even when there was nearly and I believe that was a drug case, so I could imagine that the evidence was overwhelming. But even in those circumstances, the appellate court said that the defendant is entitled to a new trial. And let that trial attorney at round 2, let them make their best argument at that point. But I think they deserve a new trial. I think that it was unfair the way it played out. The prejudice was that the new rules led to a conviction. Had the judge not given his second argument, I think there would have been acquittals on at least one.
Okay, so I like to right-size cases, so am I correct? You're not quibbling at all with the jury instruction before the start of the deliberations?
Not
right?
at all.
Okay, and you also agree that the answer given is correct, even though there's an unfairness?
It's legally correct,
right.
But even the trial judge, he was wrestling with the very issue that brings us here, and I think he said, are you sure you want this?
He did.
If there's a conviction, there's going to be an appeal, and here we are today.
He did. Did counsel, but then the Commonwealth says, but your guy didn't ask to do any supplemental argument.
Right, and I don't think it's really, I don't think the onus should be put on the defense attorney. At the end of the day, I think the judge says it's my role to see that this trial was conducted fairly, efficiently, and in an orderly manner. And that's right out of the model jury instructions. But it wasn't. This was not orderly. The rules of criminal procedure were not followed. And I think ultimately that's the judge's responsibility, to say to the attorney, oh, by the way, you should have asked for supplemental argument. I think any trial attorney in the heat of trial, she objected. She objected strenuously, but I think once the objection was denied and the new instructions were given, I think she felt her job was done. There was nothing more she could do.
So the Commonwealth notes in its brief that there's a Guadardo issue here on the license to carry.
I think I disagree because I believe this was a 2017 case. I believe that Bruin was not decided until the early 2020s. So I don't see how we would take the holding in that case and reach back to a 2017 conviction. If I'm wrong, I'm happy to stand corrected.
Okay.
Let's move on.
Thank you very much, Counsel. We'll hear from the Commonwealth.
Good morning. May it please the Court, Hallie White Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. Just to start from the end and work backwards with regard to the Guardado issue. My reading of Guardado is that it applies to cases that were pending on direct appeal when Bruin was decided. But the court can check that. There has been no argument that the evidence in this case did not support a joint venture instruction as to all charges.
Right,
Doesn't
but
something seem just fundamentally unfair about the way this case played out?
Honestly, I've not really seen this before, and I understand that.
Probably a reason for that.
I mean, but even at first blush, doesn't it appear that there's something fundamentally unfair as to the defendant because you got a bigger theory of your case than you asked for, and then was argued by the defendant?
I don't think it's
reasonably argued by the defendant.
It was reasonably argued by the defendant, and again, the defendant's not said what else should have been argued.
But that's neither here nor there for now.
I think it is both here and there.
He's not he's not the trial attorney. And so at the time, it was an issue for the jury, right? They asked, can we apply it to all or just one?
Right.
The Commonwealth said we were only looking for it on one case, on one charge.
And I think the reason...
The judge said, listen, if we expand it, you know you're going to have an issue. You realize that, right?
And judges sometimes say things like that, and
This was a
sure
very-
there's an
very
issue,
seasoned
and that doesn't
judge.
mean it's a meritorious issue, and it doesn't mean it merits reversal.
So you don't see any fundamental unfairness?
I don't see it. I don't see any fundamental unfairness here where, in the first place, joint venture, as is well established in the Commonwealth for over 10 years, it's not a separate theory of liability. It doesn't require different proof.
Except under a joint venture or aiding and abetting theory, doesn't the Commonwealth have to show knowledge? In a case that turns on the armed piece, doesn't the Commonwealth have to show knowledge that the co-venturer was armed?
It does.
And I understand here there is evidence read in the light most favorable to the Commonwealth that gets you there, but given the issue here is about the jury instructions, don't we have to read the evidence in the light most favorable to the defendant?
I don't think we have to read it in the light most favorable to the defendant. I understand the sort of qualification of the standard for a sufficiency argument. I think if you look at the totality of the evidence here, the evidence of knowledge is close to overwhelming. You have a crime that has clearly been subject to extensive preparation and planning. Somebody went out and got matching outfits, matching police badges.
I don't think that's our concern. I think we're really laser focused on whether or not the defendant 100% knew the other guy had a gun.
I understand that, and the necessary planning is some evidence of knowledge that by one that the other was armed. The moment they came through the door, it was the Cardona testified one of them had a gun, and he hit me with it. So that's pretty clear evidence that that gun was visible. And if it's visible to the person hit by it.
The question is, was it visible before they crossed the threshold or knocked on the door?
The evidence, as
Cardona
I
wouldn't know.
recall, is that when they came in, one of them had a gun.
What does that mean? Does that mean that he had a gun visibly? Did that mean he had a gun in his
He
pocket?
hit one of the victims with it almost immediately. So, yeah, I think that suggests it was visible.
Well, no, there clearly is evidence that the jury could have taken to show that he had knowledge of the gun.
There is
But if
also-
the Commonwealth's theory was there were two guns,
I don't
and-
think that was the Commonwealth's theory.
well, then why
actually
didn't
don't
it
think
ask
it was.
for aiding and abetting on the entire thing?
I asked myself that question multiple times, and I don't know the answer. I think it was because the evidence was so strong that the defendant was the principal as to everything except standing over the second victim while the defendant was upstairs rummaging in the drawers. And if you follow the description of events by the victims in their testimony, it's there's a very strong inference that the defendant was the one who came through the door with the gun, who hit Cardona, and then went upstairs, because it was Covey who stood over the other, Polanco is the other victim, who stood over him and asked him, was yelling at him, where is the money, where is the
So you
where are
think
the drugs?
the evidence
And
could
that
have
the
shown-
defendant was the one who had hit Cardona with the gun and then gone upstairs.
So the evidence could have been either one, that the defendant had the gun or
No.
that the other guy had the gun?
I think there's a very strong inference that it was the defendant who had the gun. Because Cardona, the first one to be hit, the one who ran out and flagged down the police, said he hit me with a gun. He saw the gun. He ran out. The other one,
Covey.
Covey, was standing over Polanco while the defendant went upstairs. And it was the defendant coming down the stairs, and the officer said he saw a gun. And by the way, the defendant argued, one of the principal arguments in closing was the officer thought he saw a gun. He said he saw a gun, but what he really saw was a cell phone. So I don't know what would have been added to that. And the defendant had the
Well,
possibility
where do you
to
think the
file.
gun was found?
One gun was found.
Right, but where?
Oh, it was found, I have the same question. My understanding is it was somewhere in the proximity of the stairs where the defendant was shot, but there was also a cell phone nearby. And so there was a legitimate question for the jury, not even if the defendant still had the gun, but what it was that the officer saw in his hand. But the defendant, if I can just finish my previous thought before it escapes altogether, the defendant had the option of filing a motion for new trial here and saying what it was that would have been different in his closing.
So we have an officer who is very familiar with firearms and still may have been mistaken for a gun and a phone.
That was the defendant's argument, and clearly it appears, and this is all speculation about what the jury was thinking, but it appears that someone on the jury might have thought that was enough of a possibility that they weren't willing to convict.
So isn't that part of the problem, that we have to speculate as to what the jury was thinking when it comes to joint venture or not?
No, I think we're always speculating when we talk about what a jury's thinking. It's one reason we don't inquire into jury deliberations. I think what we're focused on here is what the defendant what defense counsel would have done differently had she known that this instruction was going to be given.
Yeah, but isn't there
And there
a
could have
relatively
been a motion for new
straightforward
trial.
answer to that question?
Sorry?
Isn't there a relatively straightforward answer to that question, which
I
she
certainly
would have,
haven't heard it yet.
she would have argued that the Commonwealth, there was one gun at best, and the Commonwealth will have to prove beyond a reasonable doubt that this defendant knew the co-venturer had a gun at various key moments.
Possibly. Or that he wasn't the one with the gun and he didn't know there was a gun. But the evidence is so strong that he did know. That in any event, we have not had an affidavit from defense counsel. We don't know that that's what would have been done differently. Given that the defendant has the burden at this stage to show how he was harmed, I think he comes up short there.
Well, he did argue that the defendant didn't have a gun, right?
Yes, he argued that what the officer saw was a cell phone and not a gun, and it was all a big misunderstanding.
So on the charges, on which charges would the jury have had to find that the defendant knew Covey was armed to convict on a joint venture theory?
I think,
I mean, I can list them
well,
off if that would help.
for the firearms charges, which,
Well, yeah.
again, the ABDW, that there was actually an instruction, the re-instruction on that, was that a firearm, that they had to find that he struck the victim with a firearm, and they convicted him on that. So that actually would not be affected, because they had to find that it was done with a firearm.
Did it matter who did it?
Yes, because there was a specific victim. He was only charged with striking.
I don't understand
Cardona.
that.
I think that's right in the indictments. He wasn't charged with striking Cardona and Polanco, I don't think. The only thing, and I think, you know, this is something that the court's rightly been concerned with, that they would have found that he knew the co-venturer was armed at the time they entered. And I think there is more than sufficient evidence to find that.
The prosecutor could have elected, the prosecutor had a choice, right?
Could have asked for a joint venture on all
He could
counts.
have, and he
upfront,
could have
yes.
elected not to ask for a joint venture on
Sure.
all of them when the judge said, do you want me to give the joint venture, after the jury questioned.
Sure.
But he didn't.
He
Why?
didn't.
Why not?
I think because the evidence supported it.
Well, that makes his case stronger, right? I mean, he could have said, well, Judge, listen, I argued only one, not all of them, so fair is fair. We'll just stick with the one.
But what the
The
prosecutor...
judge said, you sure now, right? The judge gave him the option.
I think that simply because a judge was a little nervous about doing it doesn't mean it's error, doesn't mean it's reversible error.
Different question
Far
that I'm
from
asking.
it. But I think what struck me was the comment that what governs the instructions to be given is the law, and the law is applied to the facts as they could be found, and not the Commonwealth's theory of the case.
Right, but the rule says you get to know what the ruling is before you argue.
I understand that.
So how is what happened here not a violation of that rule?
I think this court could find that, but given that counsel did not ask for a supplemental argument, objected only to the giving instruction, did not actually say, I've argued this one way and I would have argued it differently. She never said that. So
She was
any
caught
objection...
off guard. Everyone was caught off guard.
We get caught off guard all the time, Your Honor. She's obligated to preserve the issue that is being argued on appeal.
She preserved it by arguing as strongly as she could that
the instruction not be given, not that she be allowed to argue again. And again, the basis for the objection matters. And nowhere does she say, if I recall correctly, nowhere does she say, I would have argued this differently.
But she says I was prejudiced.
She doesn't say how. And again, the facts support it amply. And there's really no
But
dispute
I guess,
about that.
But the question to me is, I'm sometimes struck because the Commonwealth wants to hold defendants, not just in this case, to many, many cases, to a very high standard. And as long as the Commonwealth's willing to be held to the exact same high standard, then it wouldn't bother me. But here, his whole thing was it just joint venture on the kidnapping. That's it, and nothing else. And so that, you know, why is it not just fair to say the Commonwealth made the rules here? They could have, I mean, first of all, why the Commonwealth would ever just not use a joint venture theory is beyond, it's jaw-dropping, which is probably why none of us have ever seen this before.
I've never seen it before either, and I don't know what the thinking was. But the Commonwealth doesn't make the rules. The jury were the ones who asked the question. The Commonwealth proposed an answer to the question, and the judge accepted it. And the defendant's not shown that he was prejudiced in a way that merits a new trial. So.
What do you think the standard of review is then?
Well, I think it's substantial risk, because the defendant did not ask for what he now says he should have been given.
no,
Substantial risk.
that,
And the issue was clearly important to the jury, right? Clearly important to the jury.
Again, we don't know.
They
It was
asked the
important
question.
enough to
They
ask
asked
the
the
question.
question.
They asked the
Okay.
question, certainly.
So-
And the defendant did not object on the grounds that he now presses on appeal. He did not make the grounds clear. He did
I'm not sure that is fair, counsel. They objected that the Commonwealth had elected its theory and now was changing the rules of the game, and that as a result, that the defendant was prejudiced. She may not have been able to articulate at the spur of the moment why the defendant was prejudiced, but that's different than whether she preserved the argument.
There was an objection, but it is absolutely well-settled law that an objecting party must make clear the grounds for the
The
objection.
grounds is that the Commonwealth elected one position and changed its mind.
But the only argument offered for reversal is that the closing would have been different, and we've not heard how, and that was not pressed
That's not
below.
changing the grounds, it's trying to forge prejudice. There's a difference.
I think under either standard, the defendant has not made out a case for reversal.
Thank you both
Thank
very
you.
much. The case is submitted. Our next and third argument is 2023 P280, Commonwealth versus LEIVA. And my apologies if I mispronounced the name.
Thank you, Your Honor. It may please the Court, my name is Ethan Stiles, and I'm here on behalf of Mr. LEIVA today. And I'd like to start with the second argument and explain why we should never have been here today. That argument is that his probation violation was occurred after the effective end of his probation. Now, there is the interleaving issues with the federal and the state case that were interleaved throughout the second half of the 2010s. And essentially, the argument is that while after Mr. LEIVA had been released from his state sentence, he started serving his probation sentence immediately, notwithstanding that he was also confined on a pretrial basis for a federal offense. And by the time he had finished his federal case, he pled guilty, he was sentenced, and then he finished his federal case and he was released. By that point, his probation had expired, and then 4 months later, the home invasion, which formed the basis of the violation, the principal basis anyway, occurred. So when we consider that, at that point, the violation happened too late, and the proceedings should never have come up.
Why
why do you
doesn't Medina not control this case?
For several reasons, Justice Desmond. First of all, Medina was an STP commitment, and in those situations,
All right, go ahead, I'm sorry.
an STP commitment differs in many respects from a pretrial sentence or even a committed sentence.
I understand, but the issue is whether or not he had been released in some form or fashion, right? He went from state custody to federal custody. His feet never had any liberty in between that period, and similar to Medina, right?
Not so much, because he always had the opportunity to secure his release through a variety of means, such as bail.
Who are we talking about?
I'm sorry?
Who are we talking about?
We're talking Ms. LEIVA.
About
About what happened after he was released from his state sentence. Yes, he was confined at a federal facility, but that was a pretrial. So he had the opportunity to apply for bail, to be released. He could be returned for reasons. He could have gone out again. Until his case had finally gone to judgment in 2019 through his sentencing and plea, he was still had the potential for liberty. And so he was confined in a prison pending pretrial, and I would suggest that the opportunities there are not the same for STP individuals, because they are not confined, they're not being punished. These STP proceedings are civil, but in this case they're actually more onerous, because he cannot achieve bail, he can't do any of the things, he can't earn good time, he can't get parole.
I'm confused about which way those factors cut, and specifically why this isn't a harder case for you than in Medina, where it was a civil commitment. It seems like, frankly, the defendant in Medina had a pretty strong argument, but that's not the state of the law.
Well, the distinction that is being tried to be made here is because Mr. LEIVA was not supervised, was not on the street, therefore his probation is supposed to be stayed. Now, there is no indication that the judge expressed that, and we should be cautious about doing that, where he does...
We know the judge, when he imposed the probationary conditions, he gave him a pay or community service alternative. So you're not going to do community service while in custody. And there was a stay-away order from the victim. And so, again, you can't stay away unless you have freedom to not stay away. And so it seems to me that both of those conditions speak to what the judge, I think everybody understood, was once he's released from custody, not released from state custody. At the time, they knew that the federal case was pending, correct?
There was nothing in the transcript which said either way, which discussed the federal sentence, Justice Desmond.
Not the sentence, but the case itself.
Yes,
It was alive and well, and folks were aware of it.
it was alive and well. I'm not sure who exactly was aware of it. It's on the transcript. There's no discussion of the federal case in the transcript. So the record is unknown on this point. Obviously, Mr. LEIVA knew about it. That's all we can guarantee, and his attorney probably did too. And they may have had a lobby conference with the judge. But anyway, but going to your point, Justice Desmond, the fact that he's incarcerated does, in a sense, serve analogous purposes to the terms that you described. For example, a stay away. If he's in prison, he stays away because he's confined. He can't leave. Commit the issue of community service. Well, he may be able to work in prison and earn a pittance for his labors there. So essentially, he does serve something similar. But let me point out that
Did he report to probation as soon as he got transferred from state custody to federal custody?
no, he did not.
So that's another condition of his probation, right?
But that brings me to an important point in this case, because the probation department applied for a warrant when he was released from state custody, and was granted by the magistrate or a judge, and that prevented him from leaving the federal prison, regardless of whatever else happened with this federal case. So in that instance, that warrant said your probation starts now, not when you resolve your federal matter. It starts now. You don't leave the
Why
prison.
does it say that? Why doesn't it just say, hey, don't forget, we're still waiting for you when you walk out those federal doors?
Well, because ultimately, a warrant has to be served. It requires a restriction on liberty. The federal. Well, if he's in a state prison, the state prison authorities would be aware of it. They would have to imply it, enforce it. So whenever he got out, whether it would be on bail or after he served his sentence, he wasn't being released to the street. He was at least going to go on the bus to court and take care of his probation issue. So that happened at that time, not at some later time. And I think that is maybe the crucial instance of where, where the court could decide that his probation started then and not at a later point.
So at the beginning of your argument, you said that the home invasion was the principal case for why there was a violation. But what's the basis for that? I mean, the judge could have violated him just on the driving without a license, right?
Yes, but I don't believe that it would have been, because he spends no time on that. They simply acknowledge it, move on.
That's because it was uncontested.
Yes, it was uncontested. I think that if the driving without a license was the only thing before the judge, the results would have been very different.
Nevertheless, a probation surrender could have been brought by that singular offense to which they didn't contest.
Well,
So that's not really, we're still focusing, I think, on at the time the probation was supposed to begin.
yes, and if the court agrees with my argument, then the driving with a suspended license again falls outside the probationary period, so therefore it could not have been a valid reason to violate him. And even now, I would even suggest that if we take the period of time for which he was before he was sentenced, between the time he was released from state custody to the time he was sentenced in the federal custody, that gives us 16 months of time when he could have been out and about at liberty or potential liberty. And then if you take those 16 months and he has three and a half months after he gets released from federal custody and he's truly on the street, and still he's 3.5 months, that's more than enough time to say that he had his 18 months of probation, and therefore, the home invasion allegation came too late.
Do you have any case that where the judge intentionally imposed probationary terms at a time when the defendant was in custody?
Yes, Your Honor.
Which case is that?
Yes, Your Honor. I do know that in these cases, and I think the main case is cited in Medina, where a judge can tell the defendant that I want these conditions to apply while you're in prison. I can't remember the name of the case, but I read it last night. But in that case, if he tells the defendant these things are going to apply to you on probation, such as no contact, it's often a common instance. Then, if the defendant violates the on-probation, even though he's in custody, then yes, probation violations can occur. Proceedings can be initiated. I can get the case citation for you, Your Honor. That's the closest thing I can think of. So when that
This judge didn't do that.
no,
though,
he did
right?
not do that. I guess I did look at that last night while I was preparing for this argument. So ultimately, we have a situation where the fundamentals of the SDP situation are so different from the normal, typical someone commits another crime that we should not look to Medina as the controlling case. Because essentially, it's like if we look at the judge's intention, it almost sounds like he's presuming guilt of some future event, some future unknown event, which could impact the probationary sentence or part of his sentence. And I think that would be, unfair to the judge and the defendant. And, and the last thing I would like to say is that, on this point, is that just because supervision may be lacking, even though he is being supervised in a sense in a more stricter form, or that the probation conditions cannot be enforced as a practical purpose, that does not mean that the probation is stayed for some indefinite period of time. And the case I cite for that is Commonwealth versus, well, I actually need to mention this, Commonwealth versus Al Saud. That's 459 Mass 221 for 2021, where it's 2011 case, sorry. And in that case, the court recognized that when an alien is removed and deported from the United States, who was on conditions of probation, it recognized that as a practical matter, supervision is no longer possible. And I think the inference is, as a practical matter, the conditions of probation may not be enforceable.
What would you say the standard of review is?
I'm sorry?
Standard of review?
For the argument here.
38, yeah.
Yes, I mean, I think it's an error of law. It's an error of law. Essentially, if this court reviews it de novo. Whereas the other argument I made, the first argument is abuse of discretion. And in that case, that's a question where this court has as much. The evidence was almost all documentary, so for that point, the court can look at that as well as the original trial judge, the probation sentencing judge would have looked at. And in that case, I would suggest that the evidence showed little more nothing more than association that Mr. LEIVA may have had with these other people who some of them by their own admission had participated in this home invasion. One of them says unwillingly, the other one says he changed the story several times. Now, and all they have is, really the only person who puts Mr. LEIVA in the car is one of the co-conspirators who confessed, but not willingly. He had to be told what was going to happen to him, and he decided to change his tune about his involvement in the home invasion. And he doesn't really mention.
He says your guy was in the car, and nobody says for sure whether your guy was one of the three who got out of the car and tried to go into the home, right? He could have been one of them, maybe not.
Yes, the evidence, was conflicting on that point. The judge didn't really rely on whether didn't make a finding of whether he got out of the car or not. He says he's in the car. The assumption is he's not just an innocent bystander. He has some part in this. What part we do not know. The judge made no findings on that issue, and obviously, all that we have, other than the statement that Fetty was in the car, when Fetty lives such and such, from a guy, being spoken to 2 weeks later by the police, having been found with cash and a gun, who's in a bit of hot water, as he knows, he needs to give the police something. And all he has, after talking to them, is he's got to give them the fifth man. And so he cites off Fetty. And the only thing that Commonwealth put that ties Mr. LEIVA, who they believe is Fetty, to the incident is the phone records. Now
he names him Fetty, and there's a tattoo on his hand that says Fetty, right?
Right. Yes.
And then the girlfriend's phone, as well as the grandmother's phone, also has him close proximity with the co-defendant at the time of the invasion?
Not exactly, Justice Desmond. That's a key point. The call from Mr. Padilla Caballero, they ping his phone, so they know where his phone is. They know his phone is in the vicinity of the home invasion house. But they don't ping either the grandmother or the girlfriend's phone. So all they have are telephone calls between the Caballero phone and those two phones.
At the time?
At the time. And that's what we have to base our probation violation on, is what they have at the time, not what they might have developed later, what they might produce at trial, whatever have you. It's only at that time.
So you agree that the judge went through the Hatfield factors on the record?
Yes. But I think that he weighed them on, to the Commonwealth's benefit when he shouldn't have. And I list out in the brief why. It's pretty much only the first Hatfield factor, the personal knowledge factor, weighs in favor of the Commonwealth. The rest are either neutral or weigh against them, because you've got people who want to minimize their involvement, have got reasons to lie, and aren't very detailed. And the only corroboration are telephone calls made from the phone that may be in the car to these other phones.
So is that abuse of discretion?
Well,
that's our standard there, right?
Yes, because otherwise it's just guilt by association, because the phone, because essentially the judge said LEIVA was in the car, but the phones suggest that LEIVA was not in the car, that he's calling out, that people are calling out for whatever reasons that they call, and we don't know what they are. We have no conversations and no text. So with that, I think I will rest on my brief.
Counsel, thank you very much. We'll hear from the Commonwealth.
Morning, and may it please the Court. Andrew Doherty for the Commonwealth. I would like to acknowledge law student intern Teresa Barrett, who wrote the brief in this matter. I'm asking that the Court affirm Judge Raschudi's revocation of the defendant's probation, first because he was on probation at the time, and I think the simplest reading of Medina is the most appropriate one here, which is, although post-sentence custody may be prolonged and of uncertain duration, probation is assumed to begin when a defendant is released to the community. And absent any clear indication from Judge Salinger, there is no reason for this court to create new obstructions to Medina's conclusion.
Medina was 8 years after, right?
It was. It was 8 years after. I would say this was, the defendant was well aware that he was facing federal time. That matter wasn't brought before Judge Salinger, and one of the other things I'd just add that Medina said.
Why doesn't that fall on the Commonwealth more than the defendant? The Commonwealth knew about the federal charges, or at least it appears it knew about the federal charges.
Let's presume
he could have asked Judge Salinger to be explicit about how this was going to play out.
Well, I think it makes far more sense, especially when you look at one of the portions of Medina that talks about how it's really the defendant's omission here that they also factor in when they consider whether or not they needed more from the judge to make this statement. Here, this is something that would have only helped the defendant in doing that, right? He would have had concurrent probationary time while he was already incarcerated. It would be impossible for him to comply with probationary terms such as checking in with probation, doing community service, when he was on federal probation, right? He could be in Tennessee for all we know. So the obligation was on him, and one of the things Medina talks about is how aware the SJC was of the defendant's omissions in this regard and not bringing it forward to the judge and asking for what this court in Juzba has described as an exotic but theoretically possible thing, which is for somebody's probation to start while they are incarcerated on and after sentence. Turning to, unless there's further questions on Medina, I would turn to the sufficiency of the evidence in front of the judge. And what I'd like to say is I really only gleaned after watching these videos about 3 times and comparing and recognizing how important this phone call was. Because I think what this phone call actually does is transition the state of the evidence beyond preponderance of evidence, and we get much closer to, say, clear and convincing evidence and possibly beyond a reasonable doubt, which is that if you watch the videos, what you're going to see, and I point you to in the it's pages 125 and 126 of the defendant's appendix. You're going to see in paragraph AA, Detective Zingali narrate what these videos show you. And I can tell you, you can watch these videos yourself and see exactly what Detective Zingali is describing. What you see is that at 1917, I'm just going to use 717, the victim's BMW parks. At 1923, 5 minutes later, that's the first time that this Nissan Sentra that is rented to Kevin Lehman drives by. 5 minutes after that, it doesn't just drive by, it stops. Call it 12 minutes after that, it drives by, parks at the end of the street, and 3 men get out of the car and walk towards the victim's apartment. You see one person followed by 2 people. It then drives by another time 19 minutes later, right, at 1959, and you're going to see the same action. It drives down this street, it parks at the end of the street, and 3 men walk by. That's the one where, at that occurrence, that's when the armed home invasion occurs, because at 2009, I guess that's 8 minutes, 8 o'clock and 9 minutes, 8:09 p.m., that's when the police start arriving. What you're seeing is an ongoing casing of this, what's ultimately going to be an armed robbery. What starts this all off is, as far as the video is concerned, is at 7:17, the car parks. But that is exactly when the phone call from the defendant's burner phone calls this guy Padilla. And I recognize, if you just were to sort of read Zingali's police reports as he develops more information, there's some confusion about when that phone call was made and who it was made to and who it was made from. By the time he's testifying, he makes very clear it's a call at 7:17 p.m. From the burner phone to Padilla. There's no other way to really reasonably interpret that information. So where we get to beyond this preponderance of the evidence idea that the defendant is participating in this crime is where we see he's the lookout, right? That natural inference is he's the lookout, letting everybody know, hey, Cardona is now at his house. And then you see those careful drive-bys, the rehearsal of walking by, that sort of thing. So the judge didn't use his discretion because he had sufficient evidence to find by preponderance of the evidence that the defendant had committed this crime. Unless there are any further questions or specifics,
So are you saying the defendant was in the car as a lookout, or had he gotten out of the car at some point, or you just don't know?
I'm saying the reasonable inference is he's out of the car, because I know of no circumstance where, I can't think of any reasonable circumstance where somebody would call somebody who's also in the car with you, right? I've never called anybody when I'm in the car with them. I would call them if I was stationed outside of the car, letting them know, hey, this event occurred, it's time to get started. The other thing I would point out that you know that Padilla's phone is about a quarter, based on the GPS evidence that Detective Zingali talks about, is about a quarter of a mile away from the location of where the armed robbery occurred. So I think the reasonable inference is Mr. LEIVA is stationed as a lookout to summons in the guys who are circling the block or whoever it is that they're doing.
Hearing no further questions, thank you very much.
Thank you.
The case is submitted.
Oh, wait a minute. Oh, yeah, it is, okay. Sorry.
We are going to hear one more case and then take a brief mid-morning break. The fourth case is 2022 P1009, Commonwealth versus Rivera. Yes. I didn't say Carlos, but neither did I say any other first name. Counsel.
Justice Milkey, Justice Desmond, Justice Henry, Attorney Thomas Estes on behalf of Mr. Rivera. Sorry, I'll try to keep my voice up. May it please the court. I don't do individual voir dire. That is essentially what Judge Agostini said during jury selection in this case. He said specifically that would be individual voir dire, which is something I don't do.
But I'm looking at the sentence on my iPad, and he started the sentence, I normally wouldn't because that's an individual voir dire, which I don't do. I just do a panel, and then he invited attorneys to do whatever they wanted during their own questioning, something that, as I understand it, didn't happen during Flebot times, correct?
That's correct. But, Your Honor, I would suggest that certainly doesn't cure the problem here. Whether the attorney is conducting a panel voir dire or the judge is conducting a panel voir dire.
How was the hybrid process that the judge used here different from the individual voir dire that Flebot, on its face at least, calls for?
I'm glad you asked that question. I was going to get to that. So in Flebot, essentially the judge, and the judge wasn't wrong in doing this because Flebot created new law, but the judge at the trial said, okay, I understand that these questions about whether someone has been a victim of a child sexual assault or someone close to them has been or accused, he used 4 related questions. He recognized that it was important to inquire in that area, but he refused to bring the jurors to sidebar and ask them individually. He simply asked the panel and said, raise your hand, and was just included with all the questions. These weren't, set out to be special. If you raise your hand for any of these questions, and presumably they went through the normal course where you raise your juror card in the air and they write down the numbers, and then they bring everybody up to sidebar. Well, in that case, it turns out that somebody sitting in the panel was too embarrassed, or for whatever reason, we don't know why, did not raise his hand.
I mean, it seems, I understand your concern, but it seems like this went reasonably well, and that I think like 26 jurors did acknowledge they made that mental note and then came up and said something.
And none of them were seated, right?
And none of them were seated.
It was, I think it was 14, and there was 1 that was found to be fair and impartial, and then later the Commonwealth exercised a peremptory on that juror.
So can we back up for a minute, though?
Sure.
What do you think the standard of review is? The Commonwealth argues it's substantial risk.
I think the standard of review is whether this possibly weakened the defendant's case in some way, and I take that from the holding in Holloway, Commonwealth v. Holloway. And Commonwealth v. Holloway is, in my opinion, perhaps not your opinion, is extremely similar to this case.
What was the nature of the error in Holloway?
The judge refused to ask the question about child sexual assault. Post-Flebot, refused to ask the question about child sexual assault to the jurors individually, despite a written request by the defense attorney to ask those questions individually of the veneer.
I'm going to ask you a very specific question on the facts, which I'm having, for one, a hard time figuring out. When the judge got to the additional questions, the judge said, okay, I'm not going to ask you to raise your hand, but I want you to raise this with me when your number is called at sidebar. I don't see it in the record where the judge said, and you should tell the court officer that you would have raised your hand. It does not appear at this same time that the judge called every juror to sidebar, which would suggest that maybe the jurors did know to tell the court officers. Did the judge, first of all, call all jurors to sidebar?
I was not trial counsel, but based on my review of the record, no. He did not call every juror.
That's my reading of the transcript.
Sidebar.
So how did the jurors know to come to sidebar if they didn't raise their hand to the other questions?
They wouldn't. I mean,
but they did.
Well, some of them did. I suppose some of them just stood up. It's kind of informal. If you stand up and get in the line, I mean, I've done a lot of trials, and sometimes judges are very, very careful, and if you didn't raise your hand and your number's not on the list, you're not coming up to sidebar, but they would never refuse a juror who wanted to. If you stood up and got in the line, normal course in a trial would be, if this juror feels that he or she has something that he needs to say to the trial judge, you're going to have your opportunity.
But the judge specifically said, when your number is called, I want you to tell me.
And that doesn't appear to have happened at all. In the transcript, there's no recording of calling all the numbers of the jurors. They just go through there's nothing. It's blank, which is normal. They just ask the jurors to stand up if you raised your hand, and they get in a line. And some of the jurors who didn't, well, the other issue here, and I would suggest that this might be the issue. In a case like this, the jurors are asked a lot of questions about possible bias, possible reasons, and many, many, many jurors raise their hand more than once. So and this is part of my argument, is it is entirely possible that those 15 jurors raised their hand because they raised their hand about something else. And that's why they got in line.
No, but there are some who, at sidebar, raised an issue only with respect to these questions. For example, jurors 2 and 7.
Yes, Your Honor, you're correct.
So we know that they somehow got in line, but it's not clear.
The judge was not explicit as to how this was going to work. And I find the difference between what Judge Agostini did here and what the judge did in Flabat is a distinction without a difference. Don't raise your hand, but you're going to expose the fact that you have some issue with child sexual assault when you stand up and get in line, just like you would. I mean, the fear is
Isn't there a difference between having, the question sprung on you in open court and having to raise your hand in front of the public versus approaching the judge at sidebar? How is that different from, for example, an individual voir dire?
Well, Your Honor, I think it's a huge difference. What a juror, a potential juror, might say to the judge standing at sidebar, posed with a direct question posed to them, is different than what they're going to do sitting in the panel, which is why.
No, but
Yes.
Passing over how they got to sidebar for the moment, why is it any different that the jurors at sidebar, the judge says, why did you raise your hand? Why would you have raised your hand? And the juror reveals that. Tell me how that's different from individual voir dire.
Well, Your Honor, I think that's the reason we have the holding in Flabat in the first place. Because somebody didn't respond to the question in the panel. And it wasn't until the jury was...
No, but isn't there a difference between raising your hand in open court and responding to the judge's questions at sidebar? Isn't that more like an individual voir dire than it is?
But if you don't raise your hand or stand up, you never make it to sidebar, which was the problem in Flabat. The juror didn't raise his hand.
No, but that doesn't appear to be the case here.
But I can't prove that. I can't prove that there was a juror who had been a victim of child sexual assault or had a friend or a close family member or whatever the response would have been. I can't prove that somebody just ignored that, got on the jury, and then I have
Was there anything, given that theoretical possibility, is there anything that prevented counsel during attorney voir dire from asking that question?
No, Your Honor, but if this is the solution, then why do we mandate individual voir dire at all? If we don't have to have individual voir dire, if there's no difference between individual voir dire and just asking sort of a subtly different question to the panel, why did the SJC go out of its way to say there's a difference? When you bring someone up to the sidebar, there's a difference. They're more likely to disclose something as terribly personal as this. Just like in because there are 3 other prior cases to this, which are all involve interracial questions, and the court had found people are not going to raise their hand if they have some kind of racial bias. We really need to give them privacy and bring them to sidebar to ask these questions of the jurors.
But then you have cases like Shea, I think I'm getting the name right, where the judge said, make a mental note and keep track of that mental note.
Yes, that was Judge Vilas, and in that case, the reason, so two very, very different, I'm sorry to interrupt you.
No, what I was going to say is, and the SJC didn't like that procedure, but they said, we got to allow a zone of discretion here, and this is all post-Flabat, right?
It is, and there are two major distinctions between my case and the Shea case. The first distinction is that the attorney said, I will defer to the discretion of the court. And the second huge distinction, which the SJC talks about, is Judge Vilas, in that case, brought every single juror to sidebar and questioned them there. So there was no way that a juror could just sit back and not take part in being questioned in this manner. And the SJC still didn't like it.
I was confused. Do you think Shea helps you then? Because the SJC was unhappy with that procedure, and that seems better than what we have here.
I think Shea does help me for that reason, and also I think it helps me because the SJC, I think, at times, expresses some level of frustration when the edict is clear. Nobody's confused about what individual voir dire is. All judges know what individual voir dire is. And this judge says, I don't do that.
I get it. But in context, I mean, hybrid jury impanelment is not uncommon in the Commonwealth. And judges have a lot of discretion in how they're going to do jury impanelment, as long as we get to the heart of the questions, and the questions are asked at sidebar in an individual fashion. I mean, the judge did not prohibit you from asking, or prohibit trial counsel. Well, you weren't trial counsel, were you?
No, I was not.
Didn't prohibit trial counsel from asking any question. Ask any questions you want, I think is what the judge's language was. And so I'm trying to get to where in the jury record, typically, they record. They ask the questions, the special questions. Juror 41 holds his hand up, juror 32 holds his hand up, whatever. In this instance, he said, I don't want you to hold your card up, right? I just want you to make a note in your mind as to this subset of questions. So that's how the impanelment went, correct?
Yes.
And then when they came up to sidebar, so is it your position that there may have been some jurors who didn't hold it in their mind and didn't come to sidebar?
Well, that's exactly it, Your Honor. In Flabat, that's exactly what happened. A juror just didn't raise his hand. But then the SJC and Shea expresses the concern that somebody making a mental note might not remember they made a mental note. That's just not a good way to conduct impanelment. But I think in that case, but for the fact that the defense attorney acquiesced to the discretion of the court, it seems to me that might have been a reversal.
Well, so here the Commonwealth argues that if defense counsel did not object to this procedure and therefore it was waiver by acquiescence. What do you say to that?
Your Honor, I don't understand that argument. If you file a written motion, a motion in limine, and the judge reviews it, and you bring it up at trial, and the judge says, I don't do that, or flatly denies your motion, I don't know what else you're supposed to do. And I read cases sometimes and wonder, he's not supposed to get in a fight with Judge Agostini. He's not going to...
He says, I'll note your objection. But Judge, please note my objection. The judge says, I'm not going to do that, but I am going to do this. And is, more or less okay. And, well, Judge, I understand the court's ruling. Please note my objection.
So, Your Honor, last night, or no, it was this morning, there is a case, and I will find the case for you, that talks about preservation of an issue. And if it's an oral objection, you have to be really careful to note your objection for the record. But if it's a written motion that you have submitted to the court, there's more latitude. If the judge just denies it, I'll have to find this case. You do not have to note your objection for the record.
Right, but the judge in this case didn't just deny it. He said, I'm not going to do it in that fashion, but I'm going to do it in this fashion, which is going to get to the heart of what you're asking at sidebar.
Your Honor, I respectfully, completely disagree with you. That is not what he said. An individual voir dire is fundamentally different. If it's not fundamentally different than panel voir dire, then I lose. But I think it is. I think it is fundamentally...
You're saying he should have had every single juror come up and individually ask that question of every single juror rather than mental notes.
Yes, Your Honor, and that's exactly what's done when judges conduct individual voir dire every day across the Commonwealth. I see I'm out of time.
I want to spend at least 60 seconds on the expert issue, but
I just wanted to know how old Wyeth was when he reported sexual abuse to the authorities. That was not clear.
I'm sorry, if you could repeat that question.
How old was the Wyatt when he said he reported sexual abuse to the authorities? That's a pseudonym, but.
I believe he was in his early 20s, and so it was some years later. It was a significant period of time later that he disclosed this. And in fact, in the transcript, it's because DCF called him.
Just on the expert issue, Doubert and Lanigan are there to root out junk science.
Yes, Your Honor.
Where's the science at all here in this expert's testimony, which seems pretty commonsensical in terms of victims may delay disclosing when they're, for example, scared or embarrassed, et cetera?
That's exactly my point. It's very similar to Kavanaugh's case, where the expert is testifying to personal and anecdotal beliefs that the expert might have, but it's not science. And I would say, and I think I cited to this in my brief, I'd have to double check, but that there are some studies that say that this is just common sense. Of course, there are reasons that people delay disclosing. They're afraid or whatever it is, and I don't think any juror in this day and age
isn't that argument is not that counsel should have contested the reliability of the expert, but that there was no need for an expert because the expert's just going to testify to common sense.
Well, that's correct, because it's not science. I mean, this is an expert. All experts are subject to Daubert, Lanigan, and Kavanaugh's case makes that very, very clear.
Yeah, but you're not asking for a Doubert hearing here. I mean, you're not saying they should have asked for a Doubert hearing.
I have. I personally challenged the scientific reliability of the expert testimony. There has to be some error rate. There has to be some basis for this expert to be able to come in and say all these things about delayed disclosure. And then she delineates the different reasons that someone might delay. And I would suggest none of that is subject to expert testimony. None of that is scientific. None of that is reliable. And in the end, none of it is necessary.
Okay.
Sorry.
I think we get it.
I'm kind of over.
Thank you very much. We'll hear from the Commonwealth.
Thank you.
Counsel, if you could begin by addressing the factual question of how the jurors who would have answered yes to the second set of questions got to sidebar.
Certainly. May it please the Court, Joseph Callfloors for the Commonwealth. I was just double-checking the transcript while that question came up before the panel, and my review of the transcript, and this comports with my knowledge of the local practices, that the judges will ask a question to the whole panel, and Judge Agostini here did say I have questions 1 through 4, 2 are unrelated to this matter, but 3 and 4, please make mental note if you have a positive answer to this question, and 3 and 4 are the Flabat questions. And if you look at page 23 of volume 1, or thereabouts, Judge Agostini explains that we are going to call each juror up to sidebar by your number in some orderly fashion.
But he doesn't call each juror up by number. For example, number 3 gets skipped over. There's a suggestion that they're all going to come up, but that's not what happened, apparently.
And I haven't reviewed the record as far as if number 3 was actually present. So I just know
3 comes up later.
So when we're looking at jury numbers, they're pre-assigned. So we may have just random numbers here, jurors 1 through 80 assigned to come in that day. However, a certain number do not appear. Those numbers do not get reassigned, so there may be some gaps. And it's not necessarily in order from my experience, necessarily due to the fact that it's a long day. Some may step out to go to the bathroom. Some may just not hear, so it may get skipped around in a little bit. I do note that I want to say at least juror 3, I think, was also out of order. So I don't think that the record shows that they necessarily have to go in order, but that they're trying to do it in order.
So is it the Commonwealth's position that every juror was called to sidebar?
That would be the Commonwealth's position. I've never seen a jury impanelment where a juror is not called up to be questioned.
Well, did, once each juror got up there, did the judge ask these questions of each juror, or did they just say, did you make a mental note?
Questions 3 and 4, specifically, my quick review, the judge asked, did you make note of any questions that you answered or wish to address?
But didn't actually ask
Did
the
not
question.
specifically repeat the phlebot questions, no.
Right, because my concern about your description of Frank is that it doesn't seem, or Shay does not seem as frank as it should be, because what it says on page 168 of that case is, quote, the judge also asked the racial bias questions individually at sidebar, and that doesn't seem to have happened here.
And that is a small distinction between Shay and in this matter. I would have to concede that fact. However, the Supreme Judicial Court does acknowledge that asking the questions to the panel voir dire is not favored. However, it's not incorrect or an abuse of discretion to do it that way. Here, I see Judge Agostini applying that same standard with the wide discretion that trial judges are afforded to conduct impanelment. He made that decision informing counsel, the Commonwealth and the defendant.
To what extent are you saying that phlebot is no longer good law on this point?
Whether it's
because it does fairly specifically say, from henceforth thou shall do individual voir dire of these questions.
This is the only matter that I'm aware of that has done the phlebot questions to panel, or at least that I've seen come up in my appellate practice. I personally have not gone through asking these questions in trial practice. However, I would agree that phlebot does, by its text, say that these are to be asked in person, and I would suggest that they would be. However, looking at the wide discretion, I do not think what happened here with the acquiescence by the defendant, that Judge Agostini's practice in this case was an abuse of discretion. It was not.
Is there perhaps a difference between a true individual voir dire where the judge looks a juror in the eye and asks point blank, were you ever the victim of sexual abuse, as opposed to asking them beforehand in panel, were you ever a victim but don't raise your hand, and then having them, in a sense, volunteer that once they're at sidebar? What's the difference between those?
I can certainly see the argument that there can be a difference. However, I think it's truly up to the judge's interpretation of how it's happening. So the key difference, right, between face-to-face and asking it out to the panel at large is that credibility determination, right? So the point-blank question, do you answer positively to the phlebot questions, right? A judge can make that visual credibility determination of whether or not they're being truthful or how deeply to the core their answer goes. That kind of determination may be different than when it's done out to a panel and then they're brought forward. However, there can be still a little bit of that, I would call it like a physical credibility, like if they're nervous at sidebar. There can be still some of that nervousness presenting. However, it may be tougher to specifically attribute it to the phlebot questions.
Let's assume, for the sake of argument, that you're wrong about your assumption that all the jurors were called up, and that, for example, juror number 3, who makes a live appearance at page 82, did not either raise his or her hand or would not have raised his or her hand. And so she never came up to the original sidebar. Then how is this process different from an individual voir dire and phlebot? Because to some extent, doesn't it require the juror, the potential juror, to self-identify? And at least if the observers in the courtroom are good at card counting, you could figure out who answered yes to only questions, the phlebot questions. For example, someone inside the courtroom could have told that jurors 2 and 7 did not raise their hand in the courtroom, yet they went to sidebar, therefore they must have answered yes to the phlebot questions.
So assuming that not everybody goes to sidebar,
Yes.
I think the analysis does fall a little bit apart against the Commonwealth because it is a question that needs to be posed. So there has to be that opportunity for a juror to answer. So if we ask it out to the panel, but the juror doesn't come up, I would have to concede that that's not really an opportunity for investigation into the fairness and impartiality of a juror. However, I would disagree that they did go up and everyone was addressed.
And I'm not getting how you're saying that, though, because from what I see of the transcript, and I didn't go very far, but, I mean, just in the first 7, 3, 5, and 6 didn't go up.
And I don't know that the record's going to be absolutely clear on this point if those, and I apologize if those are some of the ones that come up later, why they are out of order or if there's an absence. I've never, in my experience, seen a impanelment judge or court officer or some court representative say, we are missing juror numbers blah, 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 blah on the record. So I do see that as a gap within this record that's presented for the panel. However, I believe that what the record does show here is that every juror went up, and that's evinced in Judge Agostini's statement that we're going to try and call everybody up in an orderly way. Right, so that was the intent.
Could have just meant, he meant whoever needs to come up, because I can't, like I said, I can't see a reference to particularly 5 and 6. Unfortunately, the transcript goes back and forth between using the hashtag and using the word number, so it's not that easy of a search.
And as far as those jurors, as I stand here before you, I do not know if they do come up later. However, that is the record we're presented with.
So, assuming that a strict version of phlebot is still good law, what are we supposed to make of a judge who says, oh, I don't do individual voir dire?
A judge says he does not do individual voir dire at all. I'm not sure I've ever seen that circumstance. I've seen some variations on how trial judges do the initial panel voir dire and then bring them up. If a judge is refusing to do individual voir dire, I truly think that's a subpar evaluation of whether or not a juror or an entire jury is going to be fair and impartial.
Well, in terms of the standard of review, the defendant says structural error. You say it's not structural error. What is your best case precedent for a standard of review here? They've cited the Holloway case.
I believe I cited to Commonwealth v. Andrade or Andrade. It's 488 Mass 553, which stands for that it's not structural error where a defendant acquiesces to a court's chosen procedure.
But that assumes the acquiescence.
Yes.
Hypothetically, were we to disagree that there was acquiescence here, where you have a juror question that is not mandated by the Constitution, is not mandated by statute, is not mandated by long-standing common law tradition, but is mandated by the SJC's superintendent's power, do we have a case on point that says what the standard of review is?
As I stand here, I do not recall one that may be as specific as you're inquiring. I just note that I cited Shea for the acquiescence off the top of my notes here.
Shea or Andre?
Oh, I'm sorry, Andrade.
So turning to Dr. Miller, the defendant is arguing that her testimony is based on anecdotal reporting rather than empirical evidence. What do you say to that?
So this idea of delayed disclosure has been around for quite some time. This court in Bougis Bugas, 59 Mass Appeals Court 375, was in 2003 citing back to Dockham 405 Mass 528 from 1989. This idea of delayed disclosure has been an idea that has been tested by the courts for a long time. In my review and preparation for this case, I don't think anyone has actually, in the motion for new trial, discussed whether or not a Daubert Lanigan would be appropriate. However, when we're reviewing what has been provided by the defendant, the journals and articles that he's cited, there's a wide range of publication dates, the best of which would be 12 years prior to the trial date. So, and I apologize, I don't have the exact case that held for the first time that delayed disclosure was appropriate by the SJC or the appeals court. However, he has brought nothing to this court or the trial court's attention that shows that something has changed since 2005, 12 years prior to trial.
Well, the counsel has phrased it in terms of, you know, should have been a Daubert or Lanigan hearing, but the strongest argument here would appear to be there shouldn't have been an expert at all. If this is what the witness was going to testify to, it's something that anybody could have testified to because it's common sense. A child who's sexually victimized, who's scared, is less likely to come forward than one who isn't scared. You know, that kind of commonsensical thing. Why couldn't each of these arguments or points be argued by the prosecutor in closing with or without an expert?
I would have to point back to Dockham where the court found that it was not in the common knowledge of a jury. As you three and the parties here stand before you, well versed within the criminal law, it may be common knowledge that there are certain factors that apply. However, in the face of a juror that has come up here, has no exposure to criminal matters, let's just assume has no experience with child sexual assaults, I think it is a live question of why. And expert testimony, which is outside of the realm of what they may have, will help the jurors come to an understanding of why this was delayed. And Dockham has been around since 1989, where they held that it was. And the appeals court case Bugis was from 2003. So certainly since then, there has been this idea that it is not within the common knowledge. Whether or not it's within the common knowledge of a juror in more contemporary times is a different question. I would argue that it still stands, that a contemporary juror has zero experience with child sexual assault. I see my time is up. If there are no further questions, the Commonwealth would rely on its brief.
Hearing no further questions, thank you both very much. The case is submitted. We're going to take a brief mid-morning break. We should be back at 11:40.
Hold on, rise, please. Court is now in recess. take bills.
Oh, gee, Matt. It doesn't reach. Oh. No, I'm just thinking, he's going to have to sit while he gives his argument so that he can get to this microphone. At least the last time we were on Zoom. And then, you know, psychological advantage of that freaking iPad. There's nothing he can do about it.
Court, all rise, please. Court is now in session. Please be seated.
Well, we're close on time. Our next case is Mackey versus Santander Bank, 2023 P 472.
Good morning, Justices. May it please the Court, I'm Michael Najar on behalf of Lisa Mackey, the appellant. Do you need any statement of the history of the case?
I mean, we're familiar with the briefs and the history.
Because that could have used up the 15 minutes pretty easily. This is the second time that we are up at the appeals court on this case. The first time the court had to determine that James Mackey, who had been the initial trustee of the JLJM Realty Trust, but had resigned in 2000 and then in 2008, signed a mortgage to Santander. It was for a line of credit for $400,000. He had signed the note for the trust, and he had signed it individually. He had signed the mortgage for the...
We have read the briefs, so we
So the court had to determine, reversing the Superior Court, that he never had regained trusteeship and had, because they had initially validated the mortgage with the concept of estoppel by deed after acquired property. And on remand, the court said, we vacate so much of the judgment as declared that the mortgage was valid on the basis of estoppel by deed and that dismissed Santander's counterclaim for unjust enrichment as moot. And we remand for further proceedings consistent with this opinion. Well, one would take that to mean we were going to go back and argue the unjust enrichment. Unjust enrichment count had been rendered moot because the Superior Court had found the mortgage valid.
Yeah, I'm not clear you're right about that. I mean, we basically, summary judgment was granted on a particular theory. We said it was wrongly granted, and so we send the case back. Why isn't every theory open at that point?
Well, there's certainly enough case law when you're dealing with going to the appeals court, heading back to court, and raising wholly new arguments. And that's what happened here.
No, but isn't that in the context of a trial? You have a trial, everyone gets their shot, and then it's over, then it's an appeal. This is summary judgment.
The summary judgment had determined, all right, that would mean you're saying, okay, you go back and you can bring serial arguments as to why your mortgage is valid, even though you lost on summary judgment after winning
Not that they lost on summary judgment, is they were unable to validly obtain summary judgment. It's not that summary judgment went against them.
It was, oh, yes, I understand that. But now you're coming back with a wholly different legal argument. Well, which was not a different legal argument. The Section 34, which had to do with the marginal reference, was raised on appeal for the first time. The Section 35, which was the basis for the last Superior Court judgment, again validating the mortgage, Section 35 is a trustee certificate. There's an argument that had been argued below. It had been referenced in the Superior Court, first Superior Court summary judgment decision. It had been referenced by the appeals court. It was not even argued on appeal. In the first appeal, Santander said, you, the appeals court, can uphold the grant of the summary judgment on any valid basis, not necessarily the basis used by the Superior Court, and argued, therefore, the marginal reference issue that is part of Chapter 184, Section 34.
Right, and we said there wasn't enough record for us to get to that,
Right.
and we remanded.
But they never even argued Chapter 184, Section 35, the trustee certificate argument.
I take it you're saying they could have argued that.
They could have argued it, I suppose, yes. Yes, they could have. And we would have addressed the merits.
That was not, the 35 argument was not in their first motion for summary judgment, right?
Actually, it was part of the motion for summary judgment. It was not part of the appeal of the motion for summary judgment.
But let's distinguish between the first
In
motion for
Superior
summary
Court,
judgment.
in Superior Court, well, this was in 2018.
Right.
In Superior Court, the trustee certificate had been argued. It was clear that the trustee certificate had been signed by somebody who, of record, was no longer trustee. So when we got to,
Right, but in the first summary judgment, that judge did not reach that issue.
that's right, the judge said didn't have to reach the issue because the mortgage was valid by estoppel by deed. So
Right.
it didn't have to deal with
So they
that.
come here and so you're saying they've raised 35 in the first summary judgment.
Now, in the
Right.
trial court.
Then they go up on appeal and they raise 34 for the first time.
Right?
And they don't raise 35 at all.
Don't raise 35 at all. It's never
Then
referenced.
we send it back and now they try to raise both.
Yes.
Right? And they lose on 34 and they win on 35.
That's right.
Okay.
The problem is, there's a lot of case law dealing with claim splitting and coming back on appeal with different arguments. And the remand, as I read the remand, says go back and deal with unjust enrichment. The court in the first appeal, had Section 35 been a potential way of validating the mortgage, and clearly the court was aware that there was a trustee certificate, the court could have just said, well, gee, the trustee certificate saves the day.
But it passed on it, right?
It went through all the analysis of uniform probate code, trust code, Mr. Mackey's, that was the original trustee, his machinations, all of that, and the whole concept of after acquired title and the terms of the trust on trying to determine did he have authority to ever resume trusteeship. So the court went through that whole analysis when they could have just said, gee, Section 35 was a trustee certificate. Oh, great.
It wasn't argued to the court, right?
Well, so my point being, now you come back and you're going to allow it, so we're going to have serial appeals. Do I get to come back if you somehow find this certificate to be valid? The certificate actually talked not about the JLJM Realty Trust. It said I am trustee of the JLM Realty Trust.
I wondered about that, and I wondered if you ever raised that issue to say this can't be a valid certificate because it doesn't have the right name on it.
No, first of all, I had not been, neither of us had been attorneys of record back when all of that initially was happening. But the reason I didn't raise it at all, like in this appeal, the certificate does refer to the trust, but says where it's recorded, and it gives the proper recording reference. So that would be kind of trivial.
Okay.
But I don't know, Judge, if you're going to now find on a second appeal that certificate signed by someone who clearly was not a trustee of record, which is why it never got argued in the first appeal, I guess I may go back and reconsider my position and say, well, gee, it wasn't even on the JLJM Realty Trust. It was the JLM Realty Trust.
I think you'd be in a different posture, though, because we would say if we said summary judgment properly entered for the bank, then you'd have to be making some sort of Rule 60 motion, which is different than what happened in the first appeal, which was we said, summary judgment should not have entered on this ground, and we sent it back. Those
Shall I deal
postures
then?
seem different.
Okay.
But you argue that even to prepare its report, Santander's agent had to have minimally performed a name search on JLJM Realty Trust. Could you unpack that a little bit, please?
Yes. If you're giving a mortgage, you have to run the name search for the JLJM Realty Trust. Because if you do, the whole marginal reference argument talks about marginally referencing where the trust is recorded. Well, if you know the trust book and page, right, you go on the registry site, And we have, I mean, these are, there in the appendix are the pages of what you get if you simply put in the book and page, and all you get, it says JLJM Realty Trust, and it's where the declaration of trust is recorded. It doesn't even tell you that the JLJM Realty Trust took title to the property that is now going to be the collateral for the mortgage. And the only way you can figure that out is to run the name search on the JLJM Realty Trust. And as soon as you do it, I mean, you see the parcel going into title with the JLJM Realty Trust. You also see James Mackey's resignation and his appointment of his sister, which was found in the first appeal to be completely invalid as a successor trustee. But on record now, I want to go back for a second to the trustee certificate itself. The trustee of record at the time that the Santander mortgage was given was Susan Johnson, his sister, even though she didn't have the authority. But she didn't sign any trustee certificate, he did.
So,
But I'm just saying, anytime you give a mortgage, right, the bank has to know, one, did you own the property you're giving as collateral? Have you deeded anything else out on it? Have you deeded, say, an easement? Have you deeded a junior mortgage? Or, excuse me, an earlier mortgage? So yes, you have to put it in, and then everything comes up.
so I think he might argue that if they just run title on the property, they don't see any other mortgages on it, and then they proceed to grant this mortgage.
You've got to, the only way to run that title on the property is to run you can run the James Mackey, you can run JLJM, but you've got to run JLJM Realty Trust. And as soon as you do, it's there in the appendix.
We don't know that they did.
We have no idea what the abstractor did.
Okay. So when I look at Section 35, it says a certificate sworn to or stated to be executed under the penalties of perjury. So first of all, what do you see as the difference between sworn to, I think we know what's stated under the penalties of perjury. But what's sworn to then?
Well, we did not contend in any of the appellate briefs that language was raised a significant issue.
I thought you were contending that he didn't sign this certificate of trustee under the proper form.
No, he was not a trustee of record.
Well, I get that, but I thought you were also arguing when they got the certificate saying falsely that he was the trustee, that he didn't use the right language, that he didn't use the language that meets
Your Honor,
Section 35.
That was argued by predecessor counsel in Superior Court.
Okay?
We never argued that in either of the appellate parts or in the, when it was remanded to Superior Court, I never made that argument. That to me, you know, is a little different language. He was swearing to it, whether it's the exact verbiage. No, the problem is he wasn't trustee at all. That's what the first appeal determined. He wasn't a trustee. He couldn't give the mortgage. So the trustee of record was Susan Johnson.
So you say that when Santander hired a new abstractor and they were able to see that Mackey had resigned.
They immediately had put a printout, and the resignation was clearly there. Yes, they were looking at it at that point, Justice Desmond, for at this point they were looking. We got to go after. We need our remedy. We haven't been paid. What Mr. Mackey did for a while is he used up the $400,000 line of credit, and then he would pay. But ultimately, he was heading toward divorce, and he was dissipating assets. The reason anybody even realized he had resigned and remembered it was that 3 years after he gave the mortgage to Santander, he tried giving mortgages to his parents that were found in the probate court to be completely fraudulent. But at the time, that was 2011, 3 years after the Santander mortgage, they realized you weren't the trustee.
So why is the record silent as to what the first abstractors discovered or didn't discover?
Again, Your Honor, neither I nor Mr. Kane were involved with the case at that point. Discovery had long been over. and then we had gone up on appeal on the issue of his authority as trustee. Never, from my perspective, why Santander didn't just sue the abstractor is beyond me. But there was never at that point a reason to look for the initial abstract. I mean, either he had either he was going to have or regain authority that would have validated the mortgage, or he wasn't.
So I understand under 35, you're just saying he wasn't the trustee, they should have figured that out, so they can't win under 35, right?
It's clearly not.
All right, and your argument under 34 was you won below, right?
You know.
Briefly, because you're out of time.
I know, Judge Henry. But if you look at even on the merits, again, the question Justice Desmond asked is very significant. If we were going to really be arguing on 34, if that was going to be allowed, and originally, you know, discovery was disallowed at their request, but what Santander did is then go directly to the Registry of Deeds and get an affidavit, which we supplemented as well. And I will say, the Registrar of Deeds said in this time period there were 500 of these where only 30 were marginally referenced. So they didn't really put a lot of significance to the marginally referencing of these resignations. But really, if that was going to be allowed as an issue, then we would have to go back and say, well, first of all, what did the abstractor do? We don't know what the abstractor did. If the abstractor comes out and says, well, here's my list, and it shows everything else that he should have seen when he plugged the name in to do the name search, but this is missing, he just clearly blew it. He or she, you know, they clearly blew it. We'll never know that. It's too old.
Explain to me how was being used here as an expert as opposed to a fact witness.
Oh, to me, he was a fact witness. I wasn't proffering him as an expert.
So how did the judge exclude him based on late disclosure of experts?
It was more, his point was, I'm not letting you get past the ban on discovery by being able to go and kind of circumvent it. That's really what I thought his point was. Was all discovery closed? I'm sorry, Your Honor?
Was all discovery closed?
Oh, gosh. Discovery had been closed many years before the first appeal.
All right.
Okay.
So.
Counsel, your time is up.
Thank you very much.
Thank you very much. We'll hear from Santander.
Thank you, Your Honors, and may it please the Court. My name is Matthew Kane on behalf of Santander Bank, N.A. Summary judgment can be and should be affirmed for several independently sufficient reasons, but I would submit that the simplest reason it should be affirmed is application of Chapter 185, Section 34. And this is regardless of whether the Howe affidavit is excluded. And that is simply because Lisa Mackey did not dispute the fact that the resignation of James Mackey filed in 2000 was not noted on the margin of the trust. And based on a plain English reading of Section 34, the effect of that admission is that the resignation is not effective as to Santander, and the mortgage was valid when given. And I don't see any way around that. Mr. Najar raised a couple of what sounded like arguments that Santander is barred from either arguing Section 34 or Section 35. I don't think those objections are valid. With respect to the raise or waive style arguments, Santander has been the prevailing party in both appeals, and that rule applies to the non-prevailing party. With respect to the law of the...
Well, he argues, though, that even if we ignore the affidavit, we still don't have information about what good title practice is.
Your Honor, that's an interesting question, and I would say what good title practice is is also admitted in the undisputed facts statement to the extent that the recitations of fact by Mr. Howe in his affidavit are effectively parroted in the statement of undisputed facts. And in every material instance, Lisa's response is not disputed. And that recitation of facts includes Mr. Howe's describing how in the year 2000 there was a physical stamp, and good title practice was essentially if a person recording a resignation wanted that to be noted in the margin of the affected trust, they could simply take the stamp, stick it on the resignation, and write in the book and page, and a clerk would go do that. So according to Mr. Howe's affidavit, that's good title practice. The affidavit's out, but the statement of undisputed facts is not, and those facts are undisputed.
My concern about your position is that and I don't know what Mr. Mackey's situation is, but if you have a true scoundrel of a spouse, your position seems to be that they can just completely fleece the ignorant or co-beneficiary. They can completely fleece them in this policy, and that the bank, who's the only one who has the opportunity to stop this, is just, not my problem, even though the bank could have asked all of the trustees, all of the beneficiaries to agree to this mortgage, or the bank could have run a search on the trust. And you're like, well, it's not my problem. That cannot possibly be what we think the law is, can it?
It's what the statute says, Your Honor,
So you're,
by its plain English. And I would push back and say, I don't think that's what happened here, and I'm not aware
you
that
think
that's
she was in on the con?
I think that she, number one, benefited from the proceeds of the home equity line of
But I
credit.
want to leave that aside, because the ruling for you would mean that somebody, or many somebodies, and I hate to say, but in this job, there are a lot of scoundrels. Okay, you have to keep reminding yourself that the world is not all scoundrels, right? That there are good people out there. But you're saying that a scoundrel could completely get away with putting a significant mortgage on a property and abscond with the funds. And the one party that's in the position, the bank, is in the position to stop it. It's not their problem.
I guess I would say it's not clear to me what Mr. Mackey, under your supposition, has gotten away with. He was also a defendant below. The foreclosure has taken place, and the bank holds a judgment against him for breach of contract. He hasn't gotten away with anything, I don't think. And to the extent the concern is that Lisa Mackey has somehow been victimized by a putative scoundrel, I would point out, as before, number one, she benefited from the proceeds of the home equity line of credit, which Mr. Mackey testified were used to benefit his family and pay for their continuing lifestyle. And more importantly, number two, the mortgage hasn't been paid since July 2012. It's been 12 years. Ms. Mackey has lived in this 3,000 square foot plus home by herself without making a single payment towards a mortgage, towards rent, towards property taxes.
She says that there's some deal about she's paying or would pay half the property taxes on it.
Credit the taxes.
Right.
We'd all love to live without having to pay a mortgage or a rent. That doesn't strike me as victimhood from where I sit. So that's how I would respond to that concern, and I would layer on top of that, we're frankly dealing with a statute that is crystal clear. It says what it says. It says recorded in the registry and noted on the margin of the trust.
And your point is her recourse is against him, not against the bank, is that?
That's 100% correct, Your Honor. And I think Justice Henry,
No, finish your answer to him.
I think I was going to transition and say I think the rule in the Godfrey versus Boston Globe case discussed in my brief is controlling here, and that is it doesn't matter that this factual question noted on the margin of the trust might be a complex question. It doesn't matter that it might be the kind of question that would ordinarily require expert testimony. In Godfrey, the factual question was whether climbing was an essential part of a press operator's job.
We're familiar with the case.
And that's a complex question, but the fact that it was admitted precluded any inquiry.
Did you argue Section 34 in Mackey 1?
I did, Your Honor. I raised it. I was new to the case following the initial entry of summary judgment, and I raised it for the first time. And the record had not been in Mackey 1 on appeal. It was not argued below at summary judgment.
So if that was the strongest footing, why wasn't it argued below?
It's a great
from the outset.
And it's a great question, and my only answer is I don't know, because I inherited the case after the first summary judgment entered.
Well, let me ask the converse, which is why wasn't Section 35 argued in Mackey 1 as an alternative ground for affirming?
Because frankly, there's a page limit. The razor wave rule does not apply to the prevailing party, and strategic decisions need to be made about what arguments to make in support of a judgment that you are defending on appeal. And the reason there's a razor wave rule, among others, is if an appellee had to deal with every possible permutation in support of a judgment that they are defending, it would just cloud the docket with arguments that are inconsequential. I could have relied on Section 35. To Justice Henry's earlier question, it was argued in the first round of summary judgments by Lisa Mackey that the trustee's certificate did not meet the statutory qualification because of the sworn under the penalties of perjury issue. That argument was made. It was not raised on appeal by either side, and it wasn't raised in summary judgment 2, and the razor wave rule attaches there, and it wasn't not only made in summary judgment 2, it wasn't made in appeal 2, so it's not an issue that's before this court.
Did you have the opportunity to see what the original abstractor did for Santander?
Your Honor, I have not.
How come? Do you not want to know that answer to that question?
I don't think it was relevant because it was undisputed that Santander did not have actual knowledge of the resignation.
How do we know that if we don't know what the abstractor saw or didn't see?
So returning back to Godfrey, the fact that it's undisputed means that's how we know that, because we've alleged it in our summary judgment record, and they said not disputed. And if Rule 9A is to have any meaning, if Rule 56 is to have any meaning, this court has said, the SJC has said, we have to take our undisputed record facts as truth. I don't think courts should be in the business of cracking open undisputed facts and looking for their own disputes. That's not what this is for, in my opinion.
Is there a clearer copy of Appendix 140 to 141? Because it seems like someone took this document and tried to make it as unreadable as possible.
What is the document, just so I know?
Well, it's sort of hard to tell. It's some sort of limited title search that I can read, but then everything after that, I mean, if I blow it up really large, it's got got a million dots on it, which make it hard to read.
I don't know the answer to that. I would like to think, though I don't recall, I would have tried to use the cleanest copy that existed, although Mr. Najar put the appendix together, so that's really a question for him.
Fair point. 140, it's 140 to 141, and it says limited title search. It says something, I think it's Fifth Serve Lending Solutions, but that's pretty hard to read. Do you agree that discovery was closed at the time you came forward with the Howe affidavit?
I do. The discovery deadlines had passed and an order had entered barring Santander from conducting additional expert discovery. Justice Milkey was exactly correct. Though Richard Howe is undoubtedly an expert with respect to title matters, he was a uniquely positioned percipient witness who worked at this particular registry since 1995 and saw how these processes worked, and his affidavit was for the point of pointing out those percipient
Well, how do you
facts.
explain the judge's theory that this was an end around the closure of discovery, just regular discovery?
I think Judge Wall was irritated, and I understand that. And I tried to explain that he was not an expert, and in his ruling on my motion for reconsideration, he doubled down on that expert conclusion, which is why I appealed from that decision, because I do think that that was incorrect as a matter of law and therefore an abuse of discretion. The simple fact is Mr. Howe was not an expert witness. So to the extent that Judge Wall derived prejudice to Lisa Mackey from that conclusion that he was an expert witness, that was in error.
But didn't he kind of shift from that? Didn't he say the error wasn't so much that it was an expert, the error was, I said discovery was closed?
He said in his order, which is attached to my addendum, that expert discovery had been precluded.
But in his ruling?
In his written ruling, he used the word expert. If I may, Your Honor, in my addendum, at page 46,
I thought he said it misses the point.
the court declined to this is in his order on the cross motions for reconsideration, Judge Wall said, the court declined to consider Howe's affidavit because Santander had obtained it after discovery closed and in contravention of the court's prior ruling that it was precluded from reopening expert discovery. Now that I read it, I concede that you're right. He does say and. So to the extent that he was relying on that, fair play. But as I said earlier, the facts in that affidavit are otherwise undisputed in the summary judgment record, and his affidavit is not necessary to conclude that Section 34 validates the mortgage when given for the simple fact that the resignation was not noted in the margin of the trust.
Can we just walk through Section 34 then? And I might at this point be getting mixed up as to what arguments were made below and what arguments are being made here. But I believe he's arguing that the commas are sort of make things a little complicated here, but it seems to say any recordable instrument purporting to affect an interest in real estate executed by any person or persons who, in the record of the registry of deeds in which the district real estate lies, and are or appear to be the trustees of a trust. So he's saying the obligation was on your client to confirm they were a trustee of a trust.
And I would say that would be a statutory interpretation that eviscerates subsection B of this statute, because if appears to be means is, then it would be meaningless to require that the resignation also be recorded, also be noted on the margin of the trust. What that interpretation would be saying is, forget subsection B. You just need to perform a full title search and figure out if the trustee is still the trustee of record or not. I think a better interpretation is the one that the land court uses in I believe it's the TLR case cited in my brief, which is not binding precedent, but the land court effectively says, interpreting Section 35 and the words appears to be, that means is there some document in the registry from which a person could conclude that they were a trustee, not is it definitive that they are. And so the use of the two words, the two phrases are on one hand or appears to be, if they're to have different meanings, then I think appears to be has to refer to the fact that there is some indication that they are, whether or not that's ultimately true, number one. And number two, I think appears to be can't mean is, because then it would be irrelevant whether the resignation was noted on the margin of the trust, and the legislature would not have had to include those words. And as we know, statutory interpretation should not read rules out of the statute. Unless there are further questions, Your Honors, I'm happy to rest on my briefs.
Hearing none, thank you both very much.
Thank you very much, Your Honor.
The case is submitted.
Would you like for us to try to see if we can come up with something cleaner and get it to the court?
If you have it, I think it would be handy, but I don't know right now if it's required.
Well, we'll take a look. If we can find a cleaner version, we'll send it.
Yeah, as I understood the answer, it is, if you can do it without spending a lot of time, that's great. If it's going to require a lot of effort and resources, then we'll find a way. Okay, thank you very much. All right, next and final case of the morning is 2023 P503, STEPHANO versus Gardner Healthcare Management, LLC.
Good afternoon, honorable justices. May it please the court, my name is Joe Desmond on behalf of the appellants. We're here to seek an order vacating the order of the Superior Court denying the motion for summary judgment.
Counsel.
I'm sorry, Your Honor?
Off to a great start.
Your name?
Joe Desmond for the appellant. Yes, thank you.
For the record, no relation.
Not that I'm aware. So we're here seeking a reversal of the Superior Court's denial of our motion for summary judgment on two claims asserted by the plaintiff. They've asserted intentional infliction of emotional distress and defamation, arising out of a more complicated factual scenario
If we were to rule in your favor, are there claims left pending?
No, there were two claims
Resolve the
dismissed
case?
on the original motion to dismiss, which were breach of contract and Chapter 93A unfair and deceptive acts and practices,
Okay.
which were decided in our favor. Part of the plaintiff's claims and some of the factual allegations that give rise to the two claims, intentional infliction of emotional distress and for defamation, we believe are barred by the COVID immunity statute. The other remaining factual allegations should fail on their own merits, separate and apart from the COVID immunity.
Could I ask you to just yell a little bit more at us than you are so I can hear you?
Absolutely, Your Honor, and it's unusual for me to be asked to speak louder, but I will do so. The immunity is pretty straightforward. We are only 4 years removed from the COVID pandemic, where the most vulnerable people lived in nursing homes and many died by the hundreds and the thousands in the Commonwealth and throughout the country. By March 16th, the Center for Medicare Services and the Department of Public Health issued directives to stop visitation in nursing homes in the Commonwealth.
Right, but she argues that, well, you argue that none of the plaintiff's family had contacted the director of nurses to obtain permission to visit, but wasn't the family called to the facility because the mother was possibly dying?
They were called by a hospice provider, who was an outside provider, not by anyone employed by the nursing home. But set that aside for a moment. I'm sorry, Your Honor.
Before we set that aside, I mean,
Yep.
you get a call, listen, your mom's dying,
Yes,
come visit.
yes.
Do you think that the natural response then is to say, wait a minute, we should call the director of nursing to see if it's okay for us to go visit?
I think if those were the facts, I would agree, no. She came with 3 other people.
Yeah.
That was not the invite.
Your mom's dying, come by yourself?
There was a call from the hospice provider, not by the nursing home or the director of
I
nursing.
understand, but I'm trying to look at it in late, kind of in a regular person's view of these facts. So you get a phone call, I get a phone call, anybody, you get a phone call. It says, listen, your mom's dying, come visit. I don't see how it would be unnatural for you to call your sister and be like, listen, I just got a phone call from the hospice to say mom's dying, we should go visit. And go visit.
I don't think it's unnatural. I think because of the time where people were dying by the thousands, and the charge was to keep COVID out of the buildings, that we suspended life as normal.
But okay, yes, okay, I get that.
But
we've carved out this exception for people who are dying.
Correct, on an ad hoc basis,
And you
case by case.
Again, you get the phone call, my mom's dying.
Yes.
I'm going to notify my brother, my sister, my kids, your grandmother's dying, and we're going to rush down to the hospice to see her. I mean, I don't see how it's reasonable to think that, given that they were reached out to, they would then think, oh, well, maybe we should call the director of nursing and see if it's okay for us to go.
They were not reached out to. She was. And the rule was 1 at a time. And when they came in with 4 and then a 5th showed up, and again, Your Honor, we're only a short time removed from, and the family had notice.
Was anybody there when they entered the building?
There was no one at the front door.
How come?
Your Honor, you may recall, the staffing was brutal in nursing homes. There's task forces established by the Department of Public Health to send the cavalry because the staff members were getting sick. They were getting screened out.
I understand. I'm not saying that your argument doesn't have some meat on the bone, but it's got some problems too.
Well, the mission was to keep COVID out of the buildings. That was the mission. And when 5 people came in, and again, there's a dispute of fact as to whether or not they were...
Nobody stopped them. They asked an employee in the facility who directed them to go upstairs. Didn't tell them, hey, listen, there's 5 of you, you can't go upstairs, as I understand the record. Sent them upstairs, right? Is that disputed?
It's disputed in as much as what we know is that there was no one on the first floor guarding the door after hours, after normal visiting hours, when there was no visitation permitted, period, without special exception. And that was an edict of the Center for Medicare Services and the Department of Public Health.
Just to put a very fine point on it, though, you agree we were in the end-of-life situation part of the COVID protocol, right? There's a carve-out for end-of-life.
The hospice provider, not an employee. Hospice is a
No, I
Medicare
get that,
benefit.
I get who called, but I'm
Yep.
saying in those letters that were sent out to the community, not the bad letter, but the just general COVID
Yes.
protocols, there was an exception for end-of-life situations.
Yes,
And we're in that, right? There's no dispute about that?
we're in that, there's no
Okay.
doubt.
All right.
We're in that. And the policy, it's dated March 16, 2020,
Right.
Record Appendix, Volume 2, page 122.
Yes, I know, it was a Monday, it was when schools finally went away, right? Because they were still thinking on the 13th that they were going to be back in school on Monday, the 16th.
And the policy actually explained that, please note, this statement is not to be interpreted as carte blanche, complete freedom to act as one wishes, and be judicious in determining when you visit, how many visits, and/or visitors you bring into the building. And, you know,
Can we actually back up
yes.
and talk about the scope of the statutory
Yes, Your Honor.
protections?
And that's why we're here.
Okay,
The doctrine
and-
of present execution.
And
There's immunity from suit and liability. This isn't a
yeah,
discretion.
but as long as the three criteria are met, and focusing for a moment on the second criteria, arranging for or providing care or treatment of the individual impacted by decisions in response to the emergency rule.
Correct. And the visitation.
How does that cover this situation? I mean, it seems like the theory of the statute is, okay, where the government is telling you that certain rules are mandated, if you follow those, you're protected.
Correct.
So long as it doesn't fit these exceptions. But the second prong in particular seems to refer to the patient, not you can do some tort on a visitor.
Assume that to be the case. And the nursing home regulations are clear that the right to visitation belongs to the resident. That is the affected party. And the duty was to protect the resident from getting COVID and the other 100-some-odd residents that were in that building. The visitor has no right to be in private property. I can't walk into a nursing home and say, I'm a visitor, I want to see Justice Desmond. I don't have that right. Justice Desmond has the right to say, I want to see Desmond. So they are arranging for the care, and there's, the Center for Medicare Services and the Department of Public Health has no jurisdiction over some
But it
visitor.
obviously, it doesn't protect or immunize. If they slug Judge Desmond as he's coming to visit.
But she's got no right to be on that private property, but for the de facto invitation from her mother.
Well, but
The patient
Who's
affected,
speaking, though? The mother at this point is on her deathbed, maybe.
Correct.
And so there's only people to speak are the daughter and the son, right?
well, the daughter, but you're talking about
Right,
a
who's the-
situation in which the duty to protect the residents, and it's not just this resident, it's every resident. And the thought that you can have 5 people coming in and to the nursing home and exposing in a period where the mandate from the Commonwealth of Massachusetts was no visitation except.
And this, you're talking about, I know the orders were in March, but this all was happening in the later part of April.
Correct, when
Right.
thousands more had died.
Right, that's why I asked that question.
Correct.
So let me just ask. One is, I know it's broader than just the resident, broader than just mom, right? I mean, I'm going to
Yes.
I'm going to give you because mom has a roommate. If mom didn't have a roommate, you're not telling me that we're trying to protect mom, who we just called you to come visit because she's on her deathbed. We're trying to protect her from getting COVID right now. I mean, that just doesn't make any sense on its face, does it?
Absolutely, Your Honor. We got to go back 4 years, when we were delousing groceries from the grocery store, in terms of what people knew then, in terms of having 4 people in the room. They couldn't have 4 people in the room. They had to wait, where are you going to put them? And there's other nursing home residents who had the right to be in their nursing home, not affected by unscreened, 5 unscreened, untested, we know nothing about them. It would be irresponsible to let 5 people wandering around that nursing home.
But you
That's what exactly
didn't
what was happening,
screen.
wasn't it?
Well, until a supervisor found out, again, you keep in mind, Your Honor, this is, you're dealing with certified nurse aides, you have people of varying levels of education and experience. We didn't have the front lines. You don't have a medical doctor at the front door with a screening test.
Right, but what was, the screening was just taking a temperature at that point, right? Remember, because
There were also questions about, have you been out of the country? Have you had any symptoms of,
And what stopped the facility from, I mean, because your weakest fact is dying mom. I mean, but that's your problem. But what stopped you from asking the questions at that point?
well, okay. There were questions asked, and there were 4 or 5 unruly people by testimony. But here's the key point that I'd like to get
Yeah,
out.
because dying mom, that's what happens when dying parents happen.
Yeah, but there's, not during COVID, Your Honor. They did not have the right to have 4 or 5 people. Had there been 4 or 5 people in there and she'd gotten COVID, can you imagine the backlash there would have been for, what are you letting 5 people in? To protect my mother. My mother had a seizure during COVID.
Okay, but can I just say, we're focusing on this small part of the facts. Some of the allegations here, in terms of, spreading rumors about them being drunk.
Yes.
In terms of requiring mandated supervision of the visits with the mother, and so forth. How do you justify those? Aren't those so far out of what would be protected by the statute?
Yes. And as I started out by saying, they're immune from suit and questions about, the questions Your Honors are asking are questions that are subject to the immunity, about could they have screened them? Because if they're negligent not having screened them, there's immunity from suit. That's what the statute says.
Yeah,
All of
but
those questions.
does that immunity cover telling rumors of that they were drunk?
No, and that's why I said on the individual merits, again, portions of the plaintiff's complaint are barred by the immunity statute. And I say that it is the decision to make them leave that night, okay? And the trial court below, already on a motion to dismiss, agreed that unlike your first case today, this 59H petitioning activities, there are certain petitioning activities that can't be the basis of intentional infliction of
On the
motions.
police, the no trespass orders,
Yes, Your Honor.
those both were protected.
Correct. And I will also agree, Justice Milkey, that the one that strikes me as the only one, again, insults, saying that you're drunk is not actionable as intentional infliction of emotional distress. It just isn't on its own merits. In the case...
Can it be defamatory? Assuming it's not true?
Well, the defamation, it could be defamatory potentially, but she's got no actual damages. And if we can get to the one at a time, and to take the defamation, if I assume that someone's drunk on a particular occasion, could it hypothetically be defamatory? Yes, it hypothetically could be. But on the summary judgment record, they were unable to show actual damages. She agreed she had no actual damages. So we're left with one of the exceptions. It has to either impair her profession, that as I say...
Why wouldn't, given the public nature of her profession, why wouldn't even an accusation that you're not following COVID protocols be damaging?
She wasn't identified in the allegedly defamatory letter that was published. She wasn't identified.
I'm not talking about that. I'm talking about, you're saying that's the only time it got outside the...
Or internally at the nursing home. And that the plaintiff has argued that because it was said to
Well,
a nurse
for example,
internally-
the responding police officers were public officials that she dealt with. Maybe not the individuals, but the police
Right.
department.
Because in order to be defamatory without actual damages, it has to impair or go to her ability. It has to suggest that her ability to function in her profession is impaired. And the case is cited by both
Okay,
parties.
but, I mean, take the
It would
example
be-
of Boris Johnson's administration. The allegations of non-compliance with COVID protocols certainly can be damaging to...
To an administrative assistant, you know, especially in the context of someone who admits that I was reappointed after this, and I suffered no loss in money
So,
or damages.
did
And
I
that's
hear
the
you-
defamation argument.
Did I hear you correctly that you're not arguing immunity for the whole complaint?
You did, Your Honor.
Okay.
All right, so with respect to the intentional infliction of emotional distress.
Yes.
Okay. So you can't see your mom in private. I mean, when we look at the cases, first of all, we're supposed to assess the conduct kind of on a case-by-case analysis, right?
Yes, Your Honor.
Actual analysis.
Yes.
And so here you have a woman who's coming to see her dying mom and now has to be escorted or have a chaperone every time she goes to see her for the last few days, I don't want to say every time because I presume she's had like a week left, I suppose. How is that not outrageous?
In the context of this, and I think you have to take the context, in the context of a situation where the police had to be called to escort her out.
Well, I don't know that they had to be called. The police were called. I'll give you that. I don't know that they had to be. I'm unsure as to, we go from which seems to be an outfit that is very accommodating, come in, it sounds like some people got them chairs so they could have extra people sitting in the room with their mother. And then all of a sudden, I don't know what happened, but something happened, clearly, that turned all of the niceties into you have to have a full hazmat suit on and you can only go in one at a time and you have to have a chaperone to see your mom. And I'm not sure exactly what transpired, but something clearly transpired. Do we know?
Well, on the summary judgment record, we know what the other witnesses say, which is they would unruly, they wouldn't wear PP, protective equipment, and that's why the police were called. On the summary judgment record, in the light most favorable to the plaintiff, it just flipped. But to answer your question on intentional infliction, liability cannot be predicated on insults, indignities, threats, annoyances, oppressions, or trivialities. And it's not enough that the defendant acted with an intent which is tortious or even criminal, or that he is intended to inflict emotional distress, or even that his conduct has been characterized by malice.
I get it. But yet there are cases that survive that standard. And so the question is...
At least on summary judgment.
At least on summary judgment. And so the question is, going to see my dying mom, is this one of them? That when they're imposing a condition that I have to be chaperoned in, is this one of those?
Well, again...
doesn't sound like a triviality to me.
Well, the chaperoning, when in the context of, on that specific issue, the judgment call, again, we're in hospice and we're still, that one might be back into the immunity, in that what judgment calls were made, what conditions were put on, which were absolutely required by the Commonwealth to control a situation in terms of visitation, that would be subject to the immunity. And I don't think it reaches the level of outrageous conduct that can't be tolerated in any civilized society, where there's, in the context of protecting people from getting COVID. And she did have a roommate. And so, again, having her with someone with a history of causing a fracas in their minds, and this is beyond what we can judge, because the immunity statute says even if they were negligent with respect to that determination, if they're even negligent, it's still subject to liability from immunity. They're immune from suit.
Now,
and we can't get into that factual underpinning.
You argue in part she needed a medical expert on the argument about exacerbation of her Parkinson's.
Yes, Your Honor.
Why wasn't there a medical expert here where the therapist says this exacerbated her Parkinson's symptoms?
Well, the only note you have is from a therapist who's not qualified to testify on exacerbation of a progressive neurological condition.
Why not?
A therapist, a psychotherapist who's got no training in medicine would never, a summary judgment record, and I believe this appeals court recently ruled in a case that citation is going to escape me, that for the summary judgment record, it has to be admissible opinions from an expert when causation is needed. And to say that a therapist is in any way qualified, and she doesn't say that her Parkinson's was exacerbated. That is not in that note.
It's actually kind of, at best, ambiguous, what she said.
It does not reach to a reasonable degree of certainty that her progressive neurological condition of Parkinson's disease was worsened, and then if worsened, by which action? Because again, what she went in saying is that I was thrown out of the nursing home. If it's in any way related to being thrown out of the nursing home, subject to the immunity and or the petitioning activity, which is not differentiated in that social worker's note. She doesn't say, and this is part of the issue that I think the trial court had with this, is that there's so much in there, maybe some of it survives on liability, but it still has a causal relationship to the damages.
She just has anxiety. Right?
She had anxiety to start with, and she also diagnosed her with, I believe, separation anxiety because her mom died. Again, that's in the context of she lost her mom. She genuinely was hurt by the loss of her mom, independent of how she died.
Am I correct that neither the application for the no trespass order nor the order itself is in the record?
I'm sorry, Your Honor, repeat that, please.
Neither the application for the no trespass order nor the no trespass order itself is in the record.
It's not in the record, Your Honor.
Can I, this is an impertinent question, but if even a fraction of what the plaintiff is saying is true, then at a minimum, the nursing home overreacted, which in part is perhaps understandable given the early days of COVID, but there's a lot of, for lack of a better term, untoward overreactive behavior here, such as the supervision of the visitation. If that is true, regardless of whether or not the plaintiff is owed money, she would seem to be owed an apology. Was there any effort here by the nursing home to say, we screwed up. We realize in hindsight, your mother was dying. We wish we had done it differently. We're sorry.
I don't think there is, but Your Honor, what's missing, because you're getting the summary judgment argument in fairness, which is the light most favorable to the plaintiff. Not that...
No, I hear you, but even, I'm assuming when we resolve this, we're going to take the facts in light most favorable to the plaintiff. We get that. I'm actually assuming the reality is somewhere in the middle, that the woman's mother was dying and she was incredibly upset, and they were being told that they have to leave, and somebody's freaking out, and I get that. That's probably, maybe she owes an apology as well, but I'm just trying to say some disputes are better resolved outside of the courtroom than inside the courtroom.
Your Honor, my knowledge of that, I got involved when there was a $4 million demand for settlement on a 93A letter.
I get it.
So in terms of apologies,
The two women, and I don't know that they were women, so I apologize. I think they were, but I'm not sure. The two, I'm going to call them senior nurses, for lack of a better title, because I'm not sure exactly what their title was. They were both subsequently released, fired?
unrelated.
Unrelated.
Yeah. I believe that's true. Is that true? I shouldn't answer that one way or the other. I don't know offhand, Your Honor. They certainly weren't fired as a result of this.
Counsel, thank you very much. We'll
Thank you, Your
hear
Honors.
from the plaintiff.
Good afternoon, Your Honors. If you please the court, Timothy Cutler on behalf of Rachel Stefano. And if I could just go through quickly a couple of what I thought were mischaracterizations of the record, and then I think you probably have a number of questions you want to ask me. Starting with the last question, was anything done, any letters or contact with Ms. Stefano? No, not even a letter of condolence that we're sorry your mother has passed. She did not even receive even a form stamped letter of that nature.
So let me ask you this question. They reach out to her to tell her your mom is dying and you should come see her, right? Whether it's directly to Ms. Stefano or to Ms. Stefano and extended family, which I think would have been reasonable, but in any event. So that seems like a nice thing to do, right?
It is the appropriate thing, yes.
It seems like a nice and the appropriate thing to do.
Correct. I would agree.
They do that. So they come and they get there and there's nobody to greet them at the front entrance, what have you. Another employee who seemingly is nice sends them up, go ahead right upstairs to your mom's room. They head right up to mom's room. They've met with some other employees who were seemingly nice. Come on in, let me get some extra chairs for you. Doesn't sound like anything's amiss.
Correct, Your Honor.
Then what happens? Have they just lose their mind? Did they just go crazy and all of a sudden they get out? I mean, that doesn't make any sense to me.
Exactly the point I made to the trial judges. This is just crazy, just fundamental crazy behavior. They're sitting there. It's the mother and the daughter. Everyone else has left the room pursuant to the instructions of the staff there that only 2 people could be there. They're sitting at the elevator, and then they are told the police are coming.
Why?
The police. They asked. And then the 2 nurses who weren't there appear. And my client asked them a couple questions. 1, why? 2, what protocols are we not?
Aside from the protocols, I'm trying to picture what's happening in my mind's eye in this hospital.
Because
they've invited them to come. They've seated
It's
them.
absolute lunacy. They just were calling the police, get out of here, you're not supposed to be here. And end of story. We took the depositions of these 2 nurses, and they said that apparently their daughters work in the hospital, called them up at home and said, oh, these people just arrived. And one of the daughters was the one that sent them up to the room. And so they just came in. They were instructed by the director of nurses, when you get there, behave yourself, and I'm paraphrasing here, I apologize for that. Act socially appropriate there. When you get there, and she went there and she just went nuts and called the police, and we can't explain it. It is the most bizarre.
Okay, but at a minimum, that sounds like overreacting.
Oh, yes, okay, yes.
No, overreacting by
Okay, I was wondering if it was.
by the nursing home,
Sorry.
at least 1 or 2 people there. They have an obligation to protect everyone there, including, for example, the roommate in the room, and your client and her family were not screened at that point.
They were asked to be screened. They said, what are the protocols? That is the screening. And you got it right. The screening is, do you have a fever? Are you feeling ill? Have you been exposed to anyone in COVID? That is the screening. They got there. They didn't just, she's been in that place many, many times. She knew exactly her mother's room. She didn't run up to the room. She got in there. There's nothing posted on the door. There's nothing. They come in, they sign in, they're waiting around, and they finally find someone and say, what protocols, what should we do next? And they don't say, oh, stop, let me find out, screening, because they're expecting them. Because the nursing home told, and this is in the record, told hospice, tell them to come here, and the door will be locked, and there'll be someone to let them in and meet them. Well, they got there, the door wasn't locked, so they just waited, and they asked about the screening. When they got up to the 2nd floor, again, the nurses should have said, hey, Rachel.
How does that add up to either defamation or intentional infliction?
Intentional infliction. The defamation is then, when this all blows up, they're claiming, A, that they're causing all this problem, they're drinking, partying at their mother's bedside, or my plaintiff is partying at her mother's bedside.
And then, now those, just to be precise, those allegations were orally made among hospital
They were oral,
people?
and then I have to go back in the letter, and the letter talks about the unruly family coming in.
How do you deal with the fact that it doesn't identify them?
They put it at the nurses' station, and the nurses were talking about, they knew exactly what it was. They sent it to the community. The community, this is now.
Community being the nursing home?
Everyone that's associated with the nursing home, everyone with a family member.
Oh, they sent it out of the nursing home to all the families?
Yes, ma'am.
How would they?
Mailed it out, you're saying. Is that what I hear you to say? They
Because
mailed it out?
the circumstances, when you look.
Is that what I hear you to say, that they mailed it out?
Yes.
And how would the recipients outside the nursing home have any idea who they were talking about?
Because it's still a small community. It's Gardner. A lot of people are associated with that. And you can identify 5 people in which they had to call the police. This is not the vague situation where it's.
Seemed very specific. It seemed like a family of 5. I need to inform you, if it's the April 30th letter? I forget exactly. There's another thing I need to bring to your attention. We had a family of 5 and what have you, which didn't seem like the most outrageous thing in this whole fact pattern to me. Didn't strike me as the most outrageous conduct.
It's part of it, and you can start combining all of these elements. Also, I'd like to point out, this was not raised at summary judgment. the whole point, the identification. It wasn't raised, I believe it was only raised in the reply of the appeal. So as for an argument, I would argue it's waived, but
When they asked her, you asked, I believe Attorney Desmond asked Ms. Stefano at the deposition about this allegation of partying and being drunk. I didn't see a real clear answer from her. I don't think I read it. I think I had heard it somewhere. I mean, what's the answer to that question? Who said that they were partying?
The director said she was drinking and told others, and we have other depositions on that, other nurses being told on that. Ms. Stefano was told that by the nurses, that she was partying, and they had heard it from the director.
Director.
That was one of the people who was let go after?
No, the director stayed on. It was the two nurses that came in. They were a couple, and they were subsequently let go for bullying and bullying the other nurses, according to their deposition testimony.
So do you agree with your learned colleague that there is immunity for the decision to make them leave?
Say that again.
Do you agree with him that there is immunity for the decision to make the party of five leave? He's saying that there is immunity for calling the police, for getting the no trespass order, and the decition to make them leave.
No, there's not. The argument is, he calls it calling the police. No, that under the SLAPP action, they brought a SLAPP action which was denied. If you just petitioning activity, if you bring an action and it's only petitioning activity, defamation is one of the problems, only a petitioning activity, then you could be subject to a SLAPP action. If what is identified as petitioning activity is connected with other activity, it is not it's not immune. It's the whole purpose of, and I'm not trying to be pedantic, but as I understand it, the SLAPP actions is, you're a developer first started, and you bring a suit against some people challenging your development, and that's the only thing you bring the lawsuit on. You're just going after them for that specific thing. But if you brought them for that, and maybe they went on the property and they caused damage and they damaged the property, et cetera, then you could bring that action and you could bring in both the petitioning aspect and the damage to the property.
You brought a breach of contract action, right?
We did bring it.
And it got dismissed out,
that got
right?
dismissed.
And you're not appealing that, right?
No, sir. And the breach of contract was that my client had signed the contracts for, or signed off on the admittance contract, et cetera, and they had violated them and so forth. But the judge had agreed with my brother and dismissed that. And at this point, no, we're not.
So what's left is defamation and intentional infliction of emotional distress.
That's correct, Your Honor. And there's just, I want to, a couple of things. This argument about the director of nurses, that my client, that if you're seeing someone in an end-of-life situation and their policies require to contact the director of nurses, is false. If you look at Volume 2, page 120 is a letter, and it specifically says you do not have to contact the director of nurses at the end-of-life situation, which makes all the sense in the world, because end-of-life situation is not a 9-to-5 circumstance. It could happen at any time. That director of nurses may not be around. There's nothing in the DPH that says contacting the director of nurses. That was brought in.
I understand you're trying to get precise on this, but the context is still early days of COVID, where nursing homes are ground zero, and you have situations like the Holyoke Soldiers Home, and people are fearing criminal liability if they don't protect the patients.
But they asked her to come, and it wasn't just her.
No, somebody asked her to come.
And with the record is undisputed. The factual record that we put, if you look at their summary judgment, they hardly put any facts in. We put these facts in, and these are the facts that were in front of the judge, that that the nursing home called hospice.
No, I understand that. It's just, you're treating it like just a unitary, rationally functioning entity when it's an institution. Clearly, some people invited her there and were incredibly accommodating and nice when she came, and other people freaked out when they learned that there were 5 people.
But the management freaked out at their own request. They requested I'm sorry, I'm repeating myself. They requested them to be there. How can you get upset and freak out over your own request that the people showed up?
That doesn't mean they said.
Did they call the priest, and then they didn't let the priest in, right? Or
What?
the pastor, didn't they
Who
call?
called the priest?
I forget, one of the 2 head nurses that came in after my clients had arrived.
And then wouldn't let him in, right?
I'm sorry?
And then wouldn't let him in.
Wouldn't
They
let,
called the priest to the facility, and then when he got there, they didn't let him go in to see.
oh, the Reverend, yeah, he was walking in, and they told him, she ain't
The
dying
they,
tonight.
who's the they?
The two nurses
Good enough, yep.
told that the same ones that appeared and had called the police and sent him away, the ones that had been terminated, sent him away there. When the police came, they didn't ask the police, do you have a fever or anything? They didn't make the police put a mask on. They did nothing with regards to the police arriving to protect them against any activity. Nor did the nurses who actually appeared then, who had been home with their families, who came back, they weren't wearing a mask or anything, and they had just been out out in the public, and now they were back in the facility. Again, there wasn't any sense of fear. We put in the testimony of nurses that were working. They said, we don't even know what the rules were, if there were any rules.
Your time is limited, so I have a
Sorry.
couple more questions. So you seem to be arguing that the plaintiff should be able to say that her Parkinson's felt worse, and that that's sufficient. Is that right?
Say again? I'm sorry.
That your client can just say, I feel like my Parkinson's symptoms were worse, and that's
Yes,
good enough.
I believe under Rule 702, she is capable of talking about her own personal aggravation of it. We're not arguing the diagnosis of Parkinson's, it's the aggravation of it and how.
How do you get there? What's the causation? Just the B followed A, therefore A caused B?
No, every time I think of the situation, every time I think of the fact of I wasn't able to say goodbye to my mom,
Right, his problem is dying mother. Your problem is no matter what happened here, even if it was wonderful, even if the goodbye was as perfect as possible, if you had a good relationship, the death of your parent is just horrible.
But it's not just that.
Yes, but $4 million doesn't seem to
Okay,
factor
it's not
in that, whatever, it doesn't matter what the number is.
That was a
It
made-up
doesn't
number,
matter.
by the way.
It doesn't matter what the number is.
Okay.
You still have to account for the fact that death of a parent is just horrible, and so the most his client is exposed to is whatever the marginal difference is.
Correct.
But the death of the parent is still horrible.
The death of the parent is horrible. We all can deal with it. I have had friends who have committed suicide. The difference between someone who commits suicide and someone who dies is traumatic. And you just get, it comes up months, years later, just this empty feeling. If you have your parent and you can't say goodbye, my fiance, she couldn't say goodbye to her dad who was in a facility, and this was during COVID in England, and she was there, he was set off because of
This woman got to say goodbye, she just didn't get to say goodbye in private, and they forced her to put on all this gear, which I agree
Goodbye to
is...
your parents, it's not just saying goodbye, it's this, they were profoundly close. It is passing life. I was with my mother when she passed life, and the difference about being there and going through that and knowing you're holding her hand and this, it's a world of difference in how someone dies. It's not just this difference between they're dead and alive and they die. It's not that.
I understand.
We understand.
How do we know that that traumatic type of occurrence exacerbates Parkinson's? That's what I'm trying to get
Right,
a grip on.
because-
Just because she says it doesn't make it so. That's, I mean,
Okay,
she
so
said,
you-
hey, I have glaucoma.
okay.
My glaucoma's worse now because they kicked me out.
No, how about your rheumatoid arthritis?
I don't know.
Okay, but you go out and you find out when you're in hot, or he's got to go talk to her, he's got to ask her. It's not a,
If that were going to trial, don't you think the trial judge would demand expert
well,
witness on that?
we have that one, we have that we have the psychiatrist, and maybe the would, or 702, is it within the purview of the witness, of their knowledge, to testify? It's not saying, talking about technical medical matters, but
It sounds
if,
like
if bright lights, if I were to say bright lights hurt me, give me a headache, you'd first have to ask the person that. The doctor can't just through osmosis say, yeah, I know that hurts you. It would have to come from them.
Okay, then let me just switch gears for the
Yes, sir.
moment. To the extent you're arguing reputational harm
Yes.
related to her position as the executive assistant to the mayor, if you were allowed to make that argument, wouldn't you also be stuck with the Sullivan versus New York standard of needing to show actual malice? If your defamation is based on her being in a sense, a public official, doesn't that sweep in
No,
the...
she's not a public official. That she is not in the, per se, in the limelight in that sense. She is, that's like saying anyone who ever worked for the government is a public official, and you have to show malice.
No, but anyone who worked for the government who is claiming that her harm is related to her working for the government and not...
Okay, it's an issue that's not been raised. All right, I can't, it just doesn't sound right, and I apologize for the lack of intellectualism on that point. It's not an issue that's been raised or is before the court on this appeal. And the understanding I understand is if the court can find any way to support the judge's decision, that's what they're supposed to do on this. So I apologize for that.
No need to apologize. Thank you both very much. Very interesting case. Let me just close by saying that we are obviously going to do our job in terms of resolving the legal appeal as it's been presented to us. After we do that, at least one of you is going to be very upset with what we do. Always a possibility that both of you are upset with what we do. As we do our job, I really do urge you both to think about your client's interests and what would really serve those interests, because it strikes me that this is, in fact, one of those cases that is better resolved outside the courtroom than inside. So with that, we are adjourned. Our thanks to the court officers and the clerks, and the session is done.
Court all rise, please.
Thank you, Your Honors.